mark, inverted commas, close. Answering this, learned honorable coordinate bench held that within inverted commas held me observed in para 12 that within inverted commas nobody has disputed this fact that from the date of appointment or from the date of seniority granted to the petitioner is senior to respondent number 5, full stop. However, comma, respondent number 5 has objected that the seniority is not the criteria for granting additional charge of the higher post, that is principal of the college, comma, on the contrary, he has submitted that on account of pending inquiries against the petitioner, he has been deprived from the charge of the post of principal, full stop, inverted commas, close. Thus, it is evident that coordinate bench was per se dealing with the issue of grant of charge of the post of the principal, and whether at that point of time, since admittedly university had shown petitioner to be senior to the private respondent, that issue was not under consideration or under dispute, and denied the relief to the petitioner only on the ground of pendency of inquiries, and holding that getting a current charge of the post of principal does not entail any vested right, full stop. Thereafter, it is not in dispute, next para. Thereafter, it is not in dispute that petitioner had filed review petition 1438/2019, which changed the heart of the coordinate bench, and while allowing the review petition, the coordinate bench held that the petitioner was entitled to hold the charge of the principal, as there was an aspect of malice inferred by the coordinate bench, as was the sole ground for seeking review before the coordinate bench by the petitioner. Next para. It is also not in dispute that wide order dated 19/11/2020 passed in WA number 2103/19, the order passed by the coordinate bench in review was set, full stop. Next para. Though Shri Manoj Sharma, learned senior advocate, submits that not only the order passed in review was set aside, but the order of the writ court was restored. That means that the aspect of seniority was given a seal of approval by the division bench, comma, that is a disputed question which needs to be addressed herein, full stop. Next para. Issue is that
I don't say it's a disputed question. I said it's a settled.
I say it is a disputed question. You are not saying it is.
Because you have quoted me that that's my contention.
I've said that you say that since the issue of seniority has been, but according to me, it is a disputed question. Next one. Issue herein is that if the coordinate bench would have dealt with the issue of seniority, then it was on seniority on its own merits, then it was obliged to quash order dated 30/6/2018, Annexure R43, passed by the Commissioner Higher Education, which determined the seniority on the principles borrowed from the GAD circular dated 31/5/2008 and incorporated in Higher Education Department circular dated 22/7/2017, as is referred to by the Registrar of the APS University, and copy of this circular dated 22/7/2017 has been filed by the respondent state, while along with IA 2472/23 filed in compliance of order dated 10/2/2023
सर ये सर्कुलर नहीं है।
और सर OM कर दीजिए, OM
नहीं, वो-
communication
OM भी नहीं है,
communication dated।
इन्हीं के केस में कहा कि रामानुज को
हाँ,
नीचे
ठीक।
मान लीजिए इसके बेसिस।
हाँ, ठीक
ये
है।
कोई जनरल प्रोपोजिशन नहीं ले डाउन किया।
ठीक है,
ये आप
चलेगा।
देखेंगे ना सब इसमें
हाँ।
विषय है राममनोज द्विवेदी की वरिष्ठता के संबंध।
सर्कुलर नहीं,
संदर्भ
कम्युनिकेशन
इसका-
कर दीजिए, कम्युनिकेशन सर्कुलर नहीं, कम्युनिकेशन
हाँ,
कर दीजिए।
communication।
कम्युनिकेशन डेटेड इतना 22/2/2017 22
ये सर
22/2/2017 7 नहीं 22/2/2007 गलत लिखा है। आप लोग भी बिगड़ पढ़े लिखे लिखते हैं। 22/7 लिखा है आपने, 22/7 का तो कुछ है ही नहीं, 22/2 का है। यूनिवर्सिटी क्या पूरा नशे पत्ते पे चलती है क्या आपकी? यू आर ऑलवेज इंटॉक्सिकेटेड। You are responsible for spoiling the level of the higher education. पढ़ते लिखते हैं नहीं आप लोग। कैसे लिखा आपने 22/7? दीजिए इनको। और कहां 22/7 का ऑर्डर? कहां 22/7 का आदेश दिखाइए।
22/2 का होना चाहिए सर।
नहीं नहीं दिखाइए ना, तो होना क्या चाहिए? आप लोग बिगड़ पढ़े लिखे साइन करते हैं क्या?
That is the committee.
आप लोगों को गलत काम करने से फुर्सत नहीं है। कौन है इन कमेटी को मेंबर्स बताइए, इनको ब्लैकलिस्ट करेंगे हमेशा के लिए। दे विल नॉट बी एंटाइटल्ड टू फॉर्म पार्ट ऑफ एनी कमेटी बिकॉज दे आर नॉट कैपेबल ऑफ डूइंग एनीथिंग।
3 member is lordship.
हाँ, कौन कौन है?
In page 14 in the R3 lordship.
क्या है, नाम बताइए।
Professor R.N. Singh
हाँ,
and आचार्य गणितीय विज्ञान विभाग अवधेश प्रताप सिंह विश्वविद्यालय रीवा। प्रोफेसर सुभा तिवारी आचार्य अंग्रेजी विभाग
हाँ।
एंड प्रोफेसर R.N. पटेल।
पटेल साहब कौन से विभाग के हैं?
रसायन शास्त्र विभाग।
केमिस्ट्री। और शोभा तिवारी इंग्लिश
लordship
है।
लordship इंग्लिश।
हाँ, ये लिखिएगा एट दिस स्टेज व्हेन द
माननीय न्यायालय
प्रोसीडिंग
को
रजिस्टर।
बताना चाहूंगा सर।
हाँ,
ये आर एन सिंह साहब रिटायर हो चुके हैं
तो
अभी।
क्या हो गया? आगे कोई काम नहीं करेंगे यूनिवर्सिटी का। ये
सर, अभी-
सेवाएं लेना बंद कर दीजिए इनकी।
सर,
क्या लगा?
but may I sorry
At this
lordship may
stage.
observe now. Yes.
Yeah, I'll make an observation definitely. If you want observation against the registrar, then you can take it from me. It is evident that the registrar titled विकास विभाग शिक्षकों की वरिष्ठता सूची अपीली निर्णय पंजिका वर्ष 2021 से inverted commas close on page 11 has made an incorrect reference to the circular dated 22/2/2017 as circular नहीं और communication dated
दूसरा सर मैं एक बात बताऊं, ये
Communication.
दिस कम्युनिकेशन वाज नेवर एड्रेस्ड टू द यूनिवर्सिटी।
हाँ ठीक है ठीक है ठीक है बिल्कुल ठीक है, आप ठीक कह रहे हैं, वो उस पर आएंगे। क्या लिखा? (17) as 20 dated 22/7/2017, which reflects that and admitted by the registrar that 3 members of the committee, namely Shri R.N. Singh, Professor of Mathematics, Srimati Shubha Tiwari, Professor of English, and Shri R.N. Patel, Professor of Chemistry, who had appended their signatures as a member of a three-person committee, had not applied themselves to the facts and circumstances of the case. Full stop. This noting was approved by, ये किसके साइन है? हरे से।
कुलपति के हैं सर, वाइस चांसलर
has been approved by the vice chancellor। कौन है ये? राजा क्या लिखा हुआ है, क्या नाम है?
राजकुमार आचार्य।
By Shri Rajkumar Acharya on 26/12/2022, who also appears to have failed to apply his mind to the facts and circumstances of the case. Full stop. Such casual approach of the university officials reflects poorly about the conduct of the functioning of the university, since they are not represented in the individual capacity, with instead of passing any adverse orders against them, which should not be passed without giving them an opportunity of hearing. Registrar, who is present in person, is directed to cause an inquiry and issue notices for blacklisting these persons from the work of administrative importance after placing the file before the Vice Chancellor in this behalf. अभी रहने दीजिए. वाइस चांसलर अभी भी वही है, आचार्य साहब ही है क्या आपके? तो वो क्या करेंगे? वो तो खुद ही जो है मदहोश थे, खुद ही मदहोश थे. Full stop. Next paragraph. At this stage, Shri Manoj Sharma. ये क्लरिकल होता है ये.
Because
फैक्ट ये है, आपको बुरा लगेगा कि पूरी यूनिवर्सिटी सिस्टम क्लर्क चला रहे हैं. ये लोग तो वहां सिर्फ देखने के लिए जाते हैं. दे आर विजिटर्स. क्यों कहलवाना चाह रहे हैं आप? लेने दीजिए ना वाइस चांसलर को एक्शन. वाइस चांसलर तो पढ़े लिखे होते होंगे ना, पीएचडी की रिक्वायरमेंट है ना, इतना नहीं पढ़ना जानते. श्री मनोज शर्मा submits that this communication dated 22/2/2017 was never addressed to the university and where from it received that communication is still a gray area. Next para. As far as this issue is concerned, comma, the communication dated 22/2/2017 from the Office of the Commissioner Higher Education is addressed to the Additional Director, Regional Office Higher Education, Rewa Division, Rewa. That means that Additional Director who has a supervisory authority over the university must have communicated this communication dated 22/2/2017 to the university. Next para. It is also true that neither the GAD circular dated 31/5/2008 nor communication dated 22/2/2017, though they are part of the record at least from 10 ये कब फाइल किया था ये आपने? आपसे नहीं पूछ रहे, स्टेट से पूछ रहे. which was filed by the state on 17 फरवरी 2023 while IA 2472/23 were never put to challenge by the petitioner. Next pair. Coming back to the main issue of seniority, comma, issue in regard to seniority is to be dealt with in regard to having regard to the established principles of established principles as laid down in case of Yogendra Prasad Mandal, that seniority of an surplus employee absorbed somewhere else is to be counted from the date of his absorption and not from any past date. Full stop. As far as order annexure P7 is concerned, that regularizes the past services of the petitioner as were rendered by him in the Sudarshan Mahavidyalaya, another aided non-government college, full stop. That means that for the purposes of pension, comma, for the purposes of qualifying service and for the purposes of fixation of increments, pay fixation, including grant of increment, etc., and other reliefs like Kramonati, etc., petitioner is entitled to count his services from the date of his initial appointment in the Sudarshan Mahavidyalaya. But as far as seniority is concerned, though there are passing references in the orders of the coordinate bench, but seniority will be from the date of absorption, and therefore, by virtue of that, the order passed by the university correcting the seniority list cannot be said to be faulty or illegal, calling for indulgence. Therefore, WP 8475 of 2023 deserves to be dismissed and is hereby dismissed. Next para. In view of the observations made in regard to WP 8475,
the writ petition with the university's party. I have not argued that before. The other writ petition.
Argued मतलब?
ये तो आपने पहली इसमें देखा. दूसरे में है कि जो मेरी सीनियरिटी चेंज की है, वो तो मेरे पीठ पीछे के नेचुरल जस्टिस वाला तो आपने कंसिडर नहीं किया अभी.
अच्छा,
वो उसको मैं आर्ग्यू करता हूँ ना सर.
चलिए.
ये तो आप चूंकि इसका आदेश लिखा रहे थे.
अच्छा.
इसमें आपने दो इश्यूज फॉर्मुलेट की, वेदर आई एम एंटाइटल्ड टू काउंट माय सीनियरिटी,
नहीं, अब तो
और दूसरा कोऑर्डिनेट बेंच।
हाँ
जी,
वो तो ठीक है, अब
जी।
इसका बता
ये
दीजिए।
इसका जो है यूनिवर्सिटी ने किया, ये देखिए सर
जी 2.1
जी।
क्या ऑर्डर है?
अब इसमें जो 1 जनवरी से 31 दिसंबर 2023 तक की 29/12/2022 को जो फाइनल लिस्ट पब्लिश की,
जी
इसमें पहली बार अभी तक 40 साल से जब से ये कर रहे हैं मेरे संधारण,
जी।
ये पेज 24 पे आप देखेंगे 252 सीरियल नंबर पे मेरा नाम, ये मेरी तारीख जो है, डेट ऑफ करंट अपॉइंटमेंट 25/9/2025 लिख दी है
पेज 24 पे।
जी। This is the change which has come for the first time, and this change has come on 29/12/2020.
जस्ट अ मिनट। पेज 29
जी। नहीं सर, ये पेज 24 पे है।
24 पे जी। कहाँ है आपका नाम?
ये सीरियल नंबर 252 देखेंगे बीच में,
252 यस।
ये 25/9/98 कर दी।
जी जी जी।
इसमें से आप देखेंगे जो इसी साल की जो प्रोविजनल लिस्ट थी, भाई प्रोविजनल सर्कुलेट की, किसी को आपत्ति होगी तो आपत्ति लेगा।
प्रोविजनल लिस्ट कब सर्कुलेट?
एक मिनट,
P10 Lordship, page 87.
P10 है सब, ये प्रोविजनल लिस्ट है
जी।
इसी साल के लिए।
हाँ।
86 पे आप देखेंगे 1/1/23 से 31/12/23 तक का, और इसमें से आप देखेंगे मेरा नाम 3 नंबर पे है। तो वेयर इज द ओकेजन फॉर मी टू,
3 नंबर पे
पेज नंबर 87 पे देखें।
हाँ।
इस पे आप देखें
एसोसिएट प्रोफेसर
जी, 31/6/8/83 जो कंसिस्टेंट है अभी तक।
हाँ हाँ।
अब ये प्रोविजनल से फाइनल तक के बीच में अगर मान लीजिए इनको चेंज करना था, तो ये बता दें मुझको कौन सा शो कॉज नोटिस दिया कि आपकी सीनियरिटी चेंज कर रहे हैं आप।
यस बताइएगा
सर, प्रिंसिपल का लेटर आता है सर, अपील करते हैं कुलपति जी के पास।
हाँ।
कोई भी अपील कर सकता है सर, तो उसमें प्रिंसिपल का लेटर आया सपोर्टिंग डॉक्यूमेंट्स के साथ।
हाँ।
यही सर जो
अपील का प्रावधान कहाँ है?
गलती से सर ये 22/7/2017 लिख दिया है, ये 22/2/2017 का आदेश जो है, जो कोर्ट
नहीं वो ठीक है। कुलपति के पास कब आई अपील आपकी?
ये अपील सर अनंत इसके प्री फाइनल लिस्ट के बाद आई सर।
हाँ किसकी अपील आई?
प्राचार्य का
ठीक
लेटर आया
है,
सर।
वो आई तो उसके बाद आपने अपील पे इनको सुनवाई का मौका दिया?
सुनवाई का मौका दिया।
कहाँ है वो
नहीं,
बता दीजिए।
बता दें कहीं पे,
बता
फिर
दें,
बात
बस
खत्म।
इतना बता दें।
Lordship, objection received Lordship, and after objection we have issued 3 lists. Lordship.
After objection,
Lordship.
did you afford any opportunity of hearing to him?
उसमें सर जब अनंतिम लिस्ट जारी होती है फर्स्ट
अंतिम में तो इनका आपने 98 नहीं दिखाया। अगर आप 98 दिखा देते
सर।
तभी ऑब्जेक्शन लगाते।
जी
जब आपने 83 दिखाया
सर।
और इन्होंने जो है सामने वाले ने ऑब्जेक्शन किया,
सर।
तो आपने क्या इनको कहा कि ये ऑब्जेक्शन प्राप्त हुआ है? क्या प्रक्रिया क्या है ऑब्जेक्शन डिसाइड करने की?
इंस्टीट्यूट 19 में
हाँ।
जो फाइनल लिस्ट जब जारी होती है सर, अनंतिम के बाद, प्री फाइनल के बाद,
हाँ।
तो उसमें 7 दिन के बाद जो 10 दिसंबर तक ज्वाइन रजिस्ट्रार उसको पब्लिश करता है सर।
हाँ।
तो उसके बाद फिर 7 दिन का समय होता है।
कहाँ है वो बताइए?
Lordship,
statute?
one list is Lordship in A1, page 7, Lordship.
A1 क्या है?
In affidavit, supporting in the affidavit.
Filing
One list we have published, Lordship.
एक सेकंड, आप बात समझते नहीं है तिवारी जी। जैसी यूनिवर्सिटी है वैसे आप हैं, आपसे जो बात पूछ रहे हैं वो बोल रहे हैं स्टैट्यूट 919 क्या है, उसमें जो है प्रावधान है अपील करने का, आप कुछ और बता रहे हैं।
Lordship, statute is Lordship P, R Lordship 3.
R3
Lordship.
filed along with the return।
Lordship.
हाँ ये बताइए, कुछ भी बहस करने से कोई थोड़ा ना हो जाएगा।
Because R2 is Lordship, because I am showing the
क्या है R3 में क्या लिखा है?
R2 is Lordship, R2.
अभी आपने R3 बोला, अब आप
Sorry,
R2 होगा।
R2 is statute.
हाँ क्या है स्टैट्यूट में बताइएगा।
Lordship, clause 6.
क्लॉज 7।
Clause 6, Lordship, in
6.
page 13.
हाँ पढ़िए।
The seniority of the finalized by the committee shall be published by the registrar not later than 10th December each year. In case of any objection, an appeal may be filed before the Kulpati within 7 days, and Kulpati decision will be final. The final list will be published on or before the 31 December by the registrar by following 2 copies of each college teaching department for displaying, 1 copy of the staff notice board of the college in concern, and another copy of the for taking available for the reference to the members of the staff the college.
जी
ये तो सर प्रोविजनल की है, उसकी करेंगे आपत्ति।
फाइनल लिस्ट के लिए अगर कोई आपत्ति आएगी, उस आपत्ति की सुनवाई कैसे होगी, ये तो बताइए।
We have issued 3 lists.
री लिस्ट मतलब?
First is provisional lordship,
हाँ।
and the second is pre-final and final.
कहाँ है बताइए, कहाँ
And
पर?
one list is lordship in page 7 A1 dated 14
एक सेकंड रुक जाइएगा प्लीज।
in IA lordship
आइए क्या है?
affidavit
हाँ,
dated
इसका पेज नंबर, इसका पेज
page
नंबर
number 7 lordship.
7 तो है ही नहीं, इसमें R1 8 लिखा है आपने।
No lordship in the affidavit lordship.
एफिडेविट ही तो पढ़ रहे हैं।
Affidavit number 2196
एफिडेविट इज 2196। अच्छा,
in A1
A1
date is mentioned lordship.
एक सेकंड रुक जाइए प्लीज।
कौन सा एफिडेविट है?
ये अभी फाइल के ना 12 तारीख को।
कौन सा? ये है ना 31/24।
हाँ, ये कब पब्लिश की गई है आपने?
ये 14/11/2022
14/11/2022। हाँ,
and again which
एक सेकंड, इसमें क्या पोजीशन थी इनकी?
in
Raman
item number
Lodge-
3
आइटम नंबर 3।
in page 8
हाँ
and date of appointment is lordship 6/8/1983
ठीक है, फिर
and again we have published the lordship P10
P10। एक सेकंड रुक जाइएगा, ये है आपकी 21IA 2196/24
lordship
के साथ लगाया है, ठीक है। फिर P10 देखें,
P10 in page 86
पेज 86। इसकी डेट क्या है?
in 9/12/2022
9/12/22।
in which
P10।
lordship in which petitioner name has mentioned lordship in item number 3
हाँ,
in assistant professors page 87
पेज 87। यस,
and date of birth is lordship 6/8/1983.
डेट ऑफ बर्थ नहीं है, डेट
I'm
ऑफ
sorry, date of appointment.
हाँ 6/8/93।
Lordship. And
83।
thereafter we have issued the P1 and
भैया,
after consider the
आप भैया तो समझना नहीं चाहते वकील साहब, यही तो बड़ी दिक्कत है।
Lordship.
ये पार्टी कार्यालय नहीं है, ये हाई कोर्ट है। यह तो बता दीजिए कि आपने इन तीनों लिस्ट में इनकी एंट्री को चेंज करने के पहले सुनवाई का मौका कब दिया? ये हाई कोर्ट है। आप बाहर बहस नहीं कर रहे हैं।
सर मैं
हाँ
सर बिफोर प्री फाइनल
हाँ
24 बिफोर सिग्नेटरी लिस्ट ऑफ 24 तो अकॉर्डिंग टू इंस्टीट्यूट 19
जी,
प्री फाइनल के पहले सर सुनवाई का मौका दिया जाता है।
तो आपने इनको कब नोटिस दिया? वो नोटिस दिखाइए।
नोटिस
ये आपकी इस वरिष्ठता सूची में स्थान जो है 1983 से अपॉइंटमेंट डेट हटाकर 98 कहाँ है वो नोटिस? अरे भैया, आपने पहली लिस्ट 14/11/2022 को पब्लिश करी, तो उसमेमें 1983 दिखाया। फिर ये आपने जो है अनंतिम जारी करी 9/12/22 को P10,
जी
उसमें भी 6/8/83 दिखाया, ठीक है।
सर
उसके बाद में आपको आपत्ति आई
आपत्ति
प्राचार्य से आपत्ति आई, तो उस आपत्ति पर आपने इनको सुनवाई का मौका दिया। यही तो दुर्गति है इस पूरे संस्थान की कि वो बाबू को मालूम है, रजिस्ट्रार को कुछ नहीं मालूम। आपका अभी अभी पोस्ट हुए हैं क्या वहां पर?
सर 2 साल हुए सर।
2 साल हो गए, मतलब आपके सामने समय की घटना है ना ये।
सर
आप लोग बिगड़ पढ़े लिखे कागज साइन करते हैं, आपको कुछ नहीं मालूम है। बाबू से पूछ रहे हैं आप हाई कोर्ट में खड़े हुए हैं। आपकी खुद की तैयारी क्या है? Can you change somebody's status without giving him an opportunity of hearing? पहले वो प्राचार्य थे तो वो अपना लिख के भेजते रहे, अपने आप को एक नंबर पे बनाए रखे। जब दूसरा प्राचार्य आ गया तो उसने उठाकर जो है उनको नीचे करने के लिए आपत्ति भेज दी, और आप सिर्फ कठपुतली बने हाथ में खेलते रहे, क्योंकि आपके पास एप्लीकेशन ऑफ माइंड है ही नहीं, आप यूनिवर्सिटी हैं। देयर इज नो वर्क फॉर एप्लीकेशन ऑफ माइंड इन अ यूनिवर्सिटी, and the registrar is so helpless, he is not able to address the court directly, he is taking help of the babu. आप तो मेरे ख्याल से गजेटेड ऑफिसर होते हैं? I'll allow 2.1, see the orders.
एक इशू था जो पहले वाले में मैंने कंस्ट्रक्टिव रेस जुडिकाटा का
वो सब हम देखेंगे,
Yes.
वो सब हम देखेंगे।
जी
2.1 will be allowed to see the orders.
मान
या लिखिएगा एक क्षण, यही पूरा कर लीजिए। क्या जहाँ वो उसको वो लास्ट पैराग्राफ जो था ना, जिसमें कहा था 2.1 इज डिसमिस, उसको हटाइएगा। एट दिस it is submitted by Shri Ved Prakash Tiwari with the aid of registrar through the clerk. क्लर्क का नाम क्या है आपके? आपके क्लर्क का नाम क्या है?
सर सीडी साहू।
हाँ, रजिस्ट्रार का नाम तो ऊपर आ गया था ना। हाँ, श्री वेद प्रकाश तिवारी with the register along with the registrar and who is being aided and assisted by the clerk Shri C.D. Sahu, that though 3 lists were published, namely one on 14/11/2022 enclosed along with affidavit filed by document number 2196/24, enclosed as annexure A1, in which name of the petitioner is shown as at serial number
प्लीज
3,
वाले में 3
पहले में 3,
showing
दूसरे में
his
3।
date of appointment, initial date of appointment as 6/8/1983, and his placement at serial number 3 in the category of assistant professors. Full stop. Thereafter, another provisional list was issued on 9/12/2022 as contained in annexure P10 in WP 8475 of 2023, and in this second provisional seniority list, again name of the petitioner is shown at serial number 3, showing his initial date of appointment as 6/8/83. Thereafter, Shri Singh है ना आप? हाँ, Singh, registrar APS University through his clerk C.D. Sahu, informs the court that some objection was received from the principal of Janta Mahavidyalaya, on the basis of which final seniority list annexure P1 was published on 29/12/2022, showing name of the petitioner at serial number 252 with his date of appointment as 25/9/1998, date of current appointment as 25/9/1998. Next para. When this court wanted to know from Shri Singh, then Shri Singh through his clerk informs this court, on instructions of his clerk informs this court that no show cause notice was ever given to the petitioner to represent against the change of seniority position and the date of current appointment. Full stop. Though heavy reliance is placed on Statute 19, but Statute 19 would have come into operation if in the provisional list petitioner's name would have been shown with his date of appointment, current appointment as 25/9/1998, then petitioner would have been obliged to represent against the same in terms of the Statute 19. But when the in the provisional first publication and the second provisional publication, date of appointment was shown as 6/8/83. There was no occasion for the petitioner to represent against the same, and therefore University was violating the principles of natural justice, and without giving any opportunity of hearing to the petitioner, changed the seniority position of the petitioner without affording him any opportunity of hearing, and therefore that action of the university being contrary to the principles of natural justice, and not only in violation of principles of natural justice but also arbitrary and illegal, is hereby cannot be given a seal of approval and is hereby quashed. Accordingly, impugned order annexure P1 is hereby quashed. The university will be free to give and show cause notice to the petitioner, and after obtaining his reply may issue a fresh gradation list as on 1/1/23. Full stop. Let these proceedings be completed within 15 days from today. Full stop. Since petitioner is represented and has a notice of these proceedings, he will file his representation along with the necessary documentary evidence within 7 days to the registrar of the APS University, who may, after taking all the material that may be produced by the petitioner, take a call and decide this and place it before the appropriate committee, which shall decide the matter within further period of 7 days. Next para. Since this issue of determination of seniority has to be made by the university first, earlier writ petition is listed after 15 days, so to afford a fair opportunity to the university to act on the representation of the petitioner. List on. The 2.1 dispose of हो जाएगी
जी,
और 2 जो है पार्ट हट करके रख लीजिएगा. लिस्ट ऑन. आज 15 तारीख है ना, हाँ 29 तक कर लेंगे. ये
15
आप कर लेंगे ना, 7 दिन में ये आज से रिप्रेजेंटेशन देंगे आपको. और पढ़ाई लिखाई करके आइएगा, मत आया करिए मेरे कोर्ट में.
22 हो गया है ना.
ऑन 1 मार्च 2024. अब लगा लीजिए फाइल में.
मिनट, मेरे को जी को बाहर तो नहीं जाना कहीं. But could it come on 4th or 5th? Probably on 1st I may not be here.
चलिए 4 मार्च कर
4th
दीजिए. सीरियल नंबर
छोटा सा मामला है साहब.
हाँ बिल्कुल छोटा सा.
24 केस का है बच्चा. इसमें व्यथित है हम P1 की कंडिका डी से.
हाँ
लेक्चर P1 माय लॉर्ड.
हाँ की खंडिका
रिलीफ
लेबर कोर्ट से अवार्ड हुआ था 24 केस में.
हाँ
उसमें इन्होंने 4-5 कंडीशन दी रिलीफ क्लॉज में.
हाँ
पेज नंबर 26 पर देखेंगे,
पेज 26
लास्ट पेज ऑफ द अवार्ड.
जी.
ये मेरे पास पिटीशन है
हाँ
WP 16/850/23.
16851/2021.
उसमें भी वही था.
सेम है सब में. एक
बताइए क्या है.
डी है विपक्षी द्वारा 1 माह में. साहब पहले मैं निवेदन कर दूं, इसमें रेस्टेट करने का ऑर्डर था या बी में?
पहले पूरे ऊपर से पढ़िए ना.
प्रथम पक्ष को
सेवा समाप्ति वैध एवं उचित नहीं है, अवैध छटनी है.
जी.
प्रथम पक्ष द्वितीय पक्ष की सेवा के पूर्व सेवा शर्त अनुसार पुनः स्थापना का अधिकारी वैकल्पिक आदेश के साथ घोषित किया जाता है. इसकी पूर्व की सेवा अवधि
निरंतर सेवा में गणना योग्य रहेगी.
हाँ
द्वितीय पक्ष को पुनः स्थापना आदेश पालन के लिए वैकल्पिक आदेश दिया जाता है. यदि प्रार्थी को पुनः स्थापित नहीं करना चाहते तो पुनः स्थापना के एवज में एक मुश्त क्षतिपूर्ति रुपए 1,95,000 रुपए
ठीक है.
एक माह में.
आप इससे दुखी हैं.
नहीं, इसके नीचे वाले से.
हाँ
उसमें देखेंगे साहब 1 माह में अवार्ड देने का है आदेश.
हाँ हाँ
सी में विपक्षी द्वारा 1 माह में क्षतिपूर्ति भुगतान न किए जाने पर प्रथम पक्ष पुनः स्थापना का एवं प्रत्येक माह श्रमायुक्त दर से वेतन पाने का
पात्र होगा।
डी को मॉडिफाई कराना चाहते हैं आप?
जी सर, इसको पेश कराना चाहते हैं। निवेदन ये था साहब।
हाँ, कि आप इनको क्या क्षतिपूर्ति देना चाहते हैं, रखना नहीं चाहते?
दे चुके साहब,
क्षतिपूर्ति दे दी?
एक
कब दी?
महीने की जगह थोड़ा सा 65 लाख कम।
तो कितने दिन में दी आपने?
हमने 7 माह विलंब से दी थी सर।
हाँ, तो 7 माह का ब्याज दे दीजिए, बाकी इसको खत्म कर देते हैं। लिखिएगा, दिस पिटीशन
सर
आपकी तो है नहीं भाई।
नहीं है, इसलिए नहीं सर कि सेक्शन 11A देखेंगे आईडी एक्ट का।
भैया आपने तो पिटीशन, यू शुड हैव चैलेंज दिस फाइंडिंग।
नहीं, हम तो सेटिस्फाइड है उस फाइंडिंग से।
सेटिस्फाइड है ना? पैसा मिल गया ना आपको?
स्पेसिफिक वो तो उन्होंने जबरदस्ती उन्होंने खाते में आजकल चलता है तो खाते में ट्रांसफर
नो
कर
एनी
दिया।
प्रोटेस्ट मैडम।
ठीक है, ठीक है, ठीक है।
खाते में ट्रांसफर कर देंगे
ब्याज
तो
दिला दे रहे हैं, डिलेड पीरियड का
का
ब्याज दिला दे रहे हैं। चलिए लिखिएगा, दिस पिटीशन इज फाइल्ड बीइंग एग्रीव्ड ऑफ।
सर 17 का अवार्ड है सर।
हाँ, कब किया है?
23 पे चैलेंज किया है।
हैं?
17 का अवार्ड है, चैलेंज।
अच्छा, बताइएगा।
बहुत मतलब मैं इसीलिए थोड़ा सा बताना चाह रहा हूँ।
हाँ, ये
पूरे
तो
बता देता हूँ मैं।
हाँ, बताइए, पहले लिमिटेशन बताइएगा।
साहब इसके बाद क्या हुआ साहब?
हाँ
इसके बाद हमने अपील की एनेक्जर P2।
हाँ,
नहीं, जब
इसमें
विलंब
क्या
से-
होगा आपको हम बता देते हैं।
नहीं साहब, सुन तो ले मेरी
हाँ,
बात।
सुनेंगे ना आपको।
इसमें क्या हुआ साहब?
इसमें कॉस्ट लगेगी।
कॉस्ट भी साहब स्वीकार है।
हाँ।
पर इसके बाद लर्नेड लेबर कोर्ट हैज अवॉर्डेड 88,000, 78,000, 2 लाख
वो
68।
पेमेंट ऑफ वेजेस एक्ट में हमने केसेस लगाए तनख्वाह की, क्योंकि
साहब
रिस्टेट किया नहीं,
मल्टीपल केसेस चलते गए साहब। वो हर महीने की तनख्वाह ले रहे हैं,
स्टे था नहीं।
हर महीने की तनख्वाह ले रहे थे साहब। हमने अपील की आईडी एक्ट इंडस्ट्रियल कोड में, वो खारिज
हाँ,
हुई।
डिले कंडोनेशन की एप्लीकेशन कहाँ है आपकी?
नहीं सर, इन माय लॉर्ड, माय रिव्यू पिटीशन इज आल्सो पेंडिंग। काइंडली
अरे रिव्यू तक मत जाइए अभी
अरे
आप।
मैं
वो
सब
तो
बता दूं।
पेमेंट
कहाँ
ऑफ
लगा है?
वेजेस एक्ट में जो
किस
ऑर्डर
नंबर-
हुआ था,
किस नंबर पे लगा है
मेरी
रिव्यू?
प्रार्थना देखें सर।
रिव्यू कहाँ लगा है बताइए?
जब P5
रिव्यू आज नहीं लगे हैं, वो अलग से पेंडिंग है।
भाई,
वो
review-
पेमेंट ऑफ वेजेस एक्ट के अंतर्गत है मॉडल।
उसको बाद में देखेंगे। लिखिएगा, these petitions are filed being aggrieved of award dated 2/6/2017 passed in ID cases by the learned presiding officer Labor Court CD, whereby learned Labor Court had issued following directions. ये हिंदी में है, एनेक्चर P1 का पेज 26 पर। पे ये ए से लेकर ई तक है, ये कॉपी कर लीजिएगा, ठीक है? फुल स्टॉप। Petitioners are this petitioners are aggrieved of observation contained in clause D, namely that in case of non-payment of amount of compensation within a period of 1 month, the laborers will be entitled to
be reinstated in service.
be reinstated, and payment of wages as decided by the labor commissioner. Full stop. It is submitted that this third relief could not have been granted once labor court had exercised its discretion and had granted leave to the petitioners to either reinstate the workmen or to pay compensation as was determined by the labor court. Full stop. Next para. Shri Manoj Chandurkar, learned counsel for the respondent workman, in his turn submits that facts of the case are different. In the year 2017, award was passed. Petitions have been filed in the year 2023. Respondents have been harassing the petitioners have been harassing the workmen, and they are being made to run from pillar to post. Therefore, workmen had filed execution proceedings in compliance of which they are getting the amount of wages as determined by.
Not getting, only orders have been.
अच्छा, क्या लिखा? Sorry. They were to get the wages as determined by the labor commissioner from time to time, but that order has yet not been complied with. It is also submitted that there is huge delay in payment of compensation as ordered by the learned labor court as contained in clause C of the relief, clause C of the order.
Which has not been challenged here.
which is not under challenge before the High Court. Next para. Taking these
एक निवेदन और करना
हाँ.
चाहूँ My lord, that order has not complied by the authority. Thereafter, my lord, workman has filed the application under Payment of Wages Act.
वो है क्या यहाँ चैलेंज में?
नहीं, मैं निवेदन
वो
कर
पहला वाला जो ऑर्डर हुआ
खारिज हुआ ना,
वो
हमारी
challenge किया तो वो हाई कोर्ट से भी अपील्ड हो गया।
वो
सर,
उसको
मैं-
वहाँ देखेंगे, उसको वहाँ देखेंगे
नहीं
ना।
खारिज हुई साहब, उसके बाद जो डिले का बता रहे हैं सीनियर हमारे,
हाँ.
तो जब वहां से हमारा इंडस्ट्रियल कोर्ट से खारिज हो गया
क्या खारिज हो गया?
अपील हमारी
अपील
हाँ.
अंडर पेमेंट ऑफ वेजेस।
फॉर नॉन कंप्लायंस ऑफ
वेजेस एक्ट की बात नहीं कर रहे। प्लीज डोंट ट्राई टू कंफ्यूज। ये जो 1,95,000 इस केस में दिया है, कंपनसेशन दिया है इन ल्यू ऑफ रीस्टेटमेंट,
जी सर,
उसका भुगतान कब किया आपने?
24/3/18 को।
24/3/18 को किया ना? हाँ, ठीक है, सभी को
जी सर,
सेम डेट है।
सबकी अलग अलग डेट,
अलग अलग डेट 5वें महीने में किया है।
24/3/18 है अधिकतर सर, अधिकतम
24/3 में तो इन्होंने डिटरमाइन किया है।
और
उसके
दिया
बाद
कब है?
दिया मेरे ख्याल से है इन्होंने 30/5/18
ठीक है,
इनके कागजात के हिसाब से लग रहा है।
ठीक है,
बाकी
ठीक है। Thus it is evident, next para, thus it is evident that the controversy is in narrow compass, whether labor court could have passed an order that in default of payment of compensation there will be an automatic reinstatement once it had already given discretion to the employer to decide either to reinstate the workman after declaring his retrenchment to be illegal or pay the compensation as determined by the labor court. Full stop. लीजिएगा, क्या है ये?
वर्कमैन नेवर चैलेंज द।
Next
अरे हम
para.
कैसे चैलेंज करेंगे
अरे
जब
भाई वो तो
challenge ही
कुछ
नहीं
भी
किया?
बोलते हैं। स्टेट की हालत बहुत खराब है। Full stop. Since the labor court had given either of the two options, third option was not available, and therefore clause D of the award is set aside, being illegal. However, to do complete justice between the parties, employer petitioner will be liable to pay interest at the rate of 9% from the date of the award of the labor court till the from the expiry of 1 month period. That is with effect from 3/7/2017, 17 है ना ये? 17 till the date of actual payment on the amount of compensation as has been determined by the labor court. Full stop. For delay and laches in filing these petitions and also not enclosing delay and laches, they will also be liable to pay cost of ₹5,000 to each of the laborers, which they may recover from the erring official after making payment in favor of the laborer. In above terms, aforesaid petitions are, in above terms, this bunch of petitions is disposed of.
number 108.
Lord, in this case, I'm filing my power today, my lord. I'm praying 2 days time to file my reply.
क्या है
My lord, this is the case where, my lord, the
Yes,
NOC was required. एक एग्जाम है साहब, I am the employee of Power Generating Company Limited. An advertisement was for,
ठीक है, you will be provisionally allowed to sit in the exam.
Lord,
My
till
lord.
date, the interview कुछ आया नहीं है.
My lord,
date
आज
आया
है
नहीं
सर.
है.
चलिए,
Nine-
हम कर देते हैं ना, नहीं आया तो मत बैठे।
19
2 days I'll file my reply, my lord.
ठीक है, कोई बात नहीं।
19th को, my lord, है, followed by the document verification.
प्रोविजनली बैठने दीजिए इनको। क्या बात, सप्लीमेंट्री लिस्ट इसमें चढ़ी नहीं है क्या? यहाँ क्यों नहीं था 108? Cause list number वहां से तो हम भी ला सकते थे, इसकी यहाँ से क्यों नहीं आ रहा ऊपर से? श्री राकेश सिंह,
Yes.
Rakesh Singh for the petitioner. Shri Anup Nair for the respondents.
2 to 4, my lord.
2 to 4. Notices were given to Shri Rahul Divakar, who usually appears for Madhya Pradesh Power Generating Company Limited on 13/2/2014 with a direction to seek instructions. Today, Shri Anup Nair prays for time to file reply. Full stop. Petitioner's grievance is that he has not been given no objection certificate for participating in the interview for the post of executive engineer, and his request for the same has been turned down. According to him, these interviews are
My lord, these orders are of October, which he is challenging now. my lord.
ठीक है are going to be held on कब हो रहा है?
19th February,
19th February,
followed by document verification, which is going to be held on 20th and 22nd.
which is going to be followed by document verification on 20 February onwards. In view of said facts and the copy of call letter cum admit card brought on record for NLC India Limited. ये क्या है NLC?
My lord, it's a Navratna company.
Neyveli Lignite Corporation.
Neyveli Lignite Corporation Limited, comma. As an interim measure, it is directed that petitioner will be permitted to participate in the interview and document verification, but the results of the interview, as far as petitioner is concerned, will be subject to the outcome of this petition. Reply may be filed by 24th February. List this case on 28 February.
Lordship, notices are to be issued to respondent number 5 NLC, because my brother is appearing for.
Notice we issued to respond number 5 कर दिया on payment of PF within 3 days, returnable 2 weeks. By speed post करिएगा.
CC today, man.
CC today.
So, please.
अरे मेरी रिक्वेस्ट थी
रिक्वेस्ट इस समय नहीं होती वकील साहब.
विड्रॉ करना है
1:30 बजे बताइएगा. कौन सा नंबर विड्रॉ करना है?
74
आप 1:30 बजे बताइएगा.
serial number 4
Arvind pencil is adjustment file pre for next week.
क्या हो गया? क्या मैटर, क्या 2009 का मैटर है ना? लिखिएगा श्री, आपका शुभ नाम?
Avesh Singh.
Avesh Singh submits that arguing counsel is on adjustment. Cases that petition is admitted for final hearing. List for final hearing in part B of the court. No, petition is already admitted.
Already admitted.
Petition is listed for final hearing in part B of the court list as per its turn and seniority. Jaldi.
serial number 5 he given to Mark Dixit.
Shri
I'm praying time to
Anshul Dikshit, learned counsel for the petitioner.
Postful
जी
record is also required, my lord, because after the employment order has been passed after departmental inquiry.
जी क्या हो गया? क्या हो गया?
Record is to be called, my
हाँ
lord.
नहीं वो तो ठीक है, जवाब क्यों नहीं दिया अभी तक आपने?
I'm praying 7 days time.
हाँ
to
हाँ
file.
बिल्कुल लिखिएगा. श्री विजय कुमार शुक्ला, पैनल लॉयर, prays for 7 days time to file reply. Case was listed on 10/2/2017. Notices were issued to the respondents
इसमें मैं
on 28/8/23. Case was listed. Then on 16/10/23. Again case was listed when panel lawyer had sought time. On 20/11/23. On request of the panel lawyer, case was adjourned. On 8/1/24. On payment of, subject to payment of cost of ₹5,000. Time was granted to, 4 weeks time was granted to file reply, failing which respondent number 1 may be directed to remain personally present before this court. Today, again, reply is not filed. Full stop. In view of such facts, subject to further cost of 20,000 to be recovered from the respondent, in addition to the earlier cost, 7 days time is granted to file reply, failing which respondent number 1 shall remain personally present.
इसमें सर इसमें केवल रिस्पोंडेंट 1 को पार्टी बनाया, प्रिंसिपल सेक्रेटरी को, और जहां से डिपार्टमेंटल इंक्वायरी हुई में उस
ऐसा कहाँ प्रावधान है बताइएगा? ऑर्डर ऑफ पनिशमेंट किसने पास किया है?
ऑर्डर तो प्रिंसिपल सेक्रेटरी।
फिर कब तक ये प्रवृत्ति चलती रहेगी कि पैनल लॉयर के ऊपर पूरा भार ठोक दिया जाए? लिस्ट ऑन 23 फरवरी 2024।
सीरियल नंबर 6 अवधेश कुमार सिंह स्टेट
पासवर्ड नहीं हो पाएगा आज। चलिए,
this is the second round of litigation that we have filed. Earlier, we have filed the representation seeking the benefit for pension, but the respondent.
बताइएगा कहाँ आपका क्लेम क्या है? आप किस पद से रिटायर हुए हैं? Where is the copy of your regular appointment?
Just my lord, it's page number 22 next to P2.
P2 कहाँ पर है आप?
So, my lord, we have earlier.
एक सेकंड। दिनांक के प्रथम इकाई भोपाल के कार्य समाप्ति के फलस्वरूप भू प्रबंधन इकाई से
सीरियल नंबर
किए गए निम्न चेनमैनों को वेतनमान इतने में रक्षक के रिक्त पद पे आगामी आदेश तक जन कर्तव्य पर उपस्थिति की तिथि से संविलियन किया जाता था। इनकी पद स्थिति प्रत्येक के सामने ठीक है। फिर उसके बाद क्या हुआ?
So, my lord, eventually that we have filed that after he was retired, so his services were not considered continuous.
Counted for the pensionary benefits.
Yes, my lord.
कहाँ है आपका इनिशियल अपॉइंटमेंट ऑर्डर? आप तो प्रोजेक्ट में अपॉइंट हुए थे ना?
जी।
यस।
प्रबंध इकाई भोपाल, क्या कौन सा त्रगस क्या लिखा है ये?
सर ये भू
P2 में क्या लिखा है? त्रगस लिखा है, त्रभस लिखा है, क्या लिखा है कि गैस लिखा है?
भू प्रबंध,
हाँ,
भू प्रबंध इकाई से सेवा मुक्ति किए जाने।
तो फिर ये
सर इसमें दिस इज द सेकंड राउंड ऑफ लिटिगेशन my lord. Earlier account मतलब the petition was filed before this honorable court which was simply withdrawn. Why annexure P
तो आप नोटिस लीजिएगा। श्री आपका शुभ नाम बताइएगा।
आर्यदित्य सिंह
जी,
आर्यदित्य सिंह।
आर्यदित्य
जी,
आर्यदित्य सिंह। His contention is that petitioner who has retired as forester his past services.
No, in the earlier petition, the plea of the petitioner was that his
जवाब फाइल करिएगा ना आप।
अभी में ये टाइम स्केल क्लेम कर रहे हैं ये।
ठीक है। अर्लियर पिटीशन क्या सॉरी अर्लियर नहीं, क्या लिखा? and his earlier services for the purpose of giving benefit of qualifying service for pension has not been computed by the state. That is, the services prior to his absorption by annexure P2 have not been taken into consideration, though he was initial. Full stop. Next para. SHRI. रिलीफ क्लॉज में आइएगा। क्या क्लेम कर रहे हैं आप?
जी,
पिटिशनर्स रिप्रेजेंटेशन डिसाइड करने के लिए बोल रहे हैं P15।
सर अब टाइम स्केल क्लेम कर रहे हैं।
my lord, the
टाइम स्केल
तो आप डिसाइड कर दीजिए।
कर देंगे सर।
पिटिशनर्स एंड
My lord, initially what happened was
Huh.
that after we filed the representation, they claimed that since the petition was
Petition
pending,
कौन बनाता है आपकी?
my learned senior.
Your learned senior. थोड़ा सा तो डिस्क्रिशन यूज कर लेते.
I apologize. With the
चुपी हो जाते इस वक्त तो थोड़ी सीनियर की इज्जत बच जाती. Petitioner's contention is that he has not been given benefit of the contention is that he will be satisfied if a direction is issued to the authorities to decide his representation as contained in NKP 15 as addressed to the conservator of forest Bhopal Circle Bhopal without commenting on merits. 15 दिन 60 दिन चली.
obliged.
Yes, figure number 41. Figure number 41.
This matter pertains to the termination of the petitioner who was the Anganwadi worker, my lord. We filed a rejoinder on.
I have a humble request. They may supply the copy of the rejoinder or they have filed.
देखिए श्रीमती संजना साहनी for the petitioner श्री
A private respondent.
Abhay Pandey for the respondent number 4. Let copy of rejoinder be supplied to respondent number 4 counsel during the course of the day. Additional return, if any, be filed within 2 weeks. List thereafter.
Prior to continuing.
IR, if any, to consider.
Figure number 61. Figure number 61. राजेश कुमार तिवारी उसके
charge of higher postman. Charge of higher post of assistant engineer has been granted to the junior of the petitioner, my lord. Respondent number 5 and 6.
Petitioner's contention is that the charge of the higher post of assistant engineer has been given to the junior of the petitioner, that is juniors of the petitioner, that is respondent number 5 and 6. Hence this petition. कहाँ है आपका अभ्यावेदन?
My lord, last date of hearing, my lord, is directed to file the reply, my lord.
जी आ गया रिप्लाई इसमें.
Respondent number 5 and 6, I have filed my reply.
हाँ आप बताइए स्टेट को क्या कहना है?
My lord, I am praying time for reply.
देखिएगा स्टेट काउंसिल has not filed reply. Let affidavit of the किसने दिया है चार्ज? respondent number 2 ने दिया है ना?
Annexer.
P4 is by respondent number 2. Personal affidavit of the Deputy Secretary, Department of Tribal Works, Mantralaya be filed within 10 days. That why and under what and how charge of the post has been given. Assistant engineer नहीं यार, assistant commissioner.
No.
Assistant engineer ठीक है. Assistant engineer ठीक है. Has been given to the juniors of the petitioner. List on 29 फरवरी 2024.
मतलब 29 के बाद कर दें, 4 को कर दें.
अच्छा ठीक है 4 कर दीजिए. 4 मार्च 2024 ठीक है.
Figure number 64. श्री राजस पौर्णिका.
On the last date, Parliament have directed the bank to file an additional affidavit detailing the payments made by them. This is with regard to areas of 5th, 6th and 7th pay commission money.
हाँ.
He retired in year 90.
Where is the compliance of this order?
My lords, may I just most humbly pray, though my return has all these details, my lords, but if I may be granted just 1 week time, I'll file the details.
You are appearing for the bank?
I'm appearing for the bank. My return was filed long back in which 5th, 6th and 7th pay commission.
Dated 1/2/2024.
It's already detailed out, my lords.
Prays for and is granted
Just
7
1 week.
days time to make compliance of the order dated 1/2/23, bringing on record all the vouchers and entries made in his account
I'll even produce all
हाँ
the
वाउचर दे दीजिएगा
मैं वाउचर दे देता हूँ दो
जी लिस्ट ऑन 22 फरवरी 2024
Serial number 77. Serial number 77. Case of compulsory appointment, madam. It's a second round of litigation.
जी जवाब आया नहीं आया
अभी notice नहीं है.
issue notice is waived by Shri Manas Mani Verma. Let reply be filed within 4 weeks, list after 4 weeks. In the week commencing 1 April 2024.
Serial number 28 is Sanjay Kumar Agarwal.
This is a transfer matter. The petitioner is working as site assistant, but by the implied order, he is sought to be transferred from PWD Division Newari to PWD Subdivision Baldevgarh Division Tikamgarh. Number, this order was passed on 6/12/2022, which is Annexure P3.
एक मिनट रुक जाइए हाँ क्या हुआ
The transfer order was
हाँ
passed.
ठीक है
But after a period of 1 year and 2 months, now they have passed a relieving order on 5/2/2020.
Where is the transfer order?
Transfer order is Annexure P3, page 38.
Petitioner's grievance is that he was transferred. P3?
P3 is the transfer order.
रमाकांत पाठक
Ramakant Pathak. His name is mentioned at serial number 1.
एक सेकंड रुक जाइएगा तो प्रधानाध्यापक कुछ है क्या
No, my lord, he is working as site assistant.
कुछ केस और खुल रहा है भाई
निवाड़ी से टीकमगढ़ हुआ था.
देख रहे हैं क्यों नहीं हाँ 2022 में
22 में
और अब रिलीव कर रहे हैं
अब 5/2/2024 को.
Petitioner's contention is that petitioner was transferred by order dated 6/12/2022 annexure P3 wherein name of the petitioner appears at serial number 1 from the post of Sthal Sahayak Niwadi to subdivision Baldevgarh Tikamgarh on administrative grounds. Now petitioner is being relieved by order dated
5/2/2024.
5/2/2024 after more than a year when transfer was made full stop. It is submitted that the transfer cannot withstand such a long period and has lapsed by on account of non-relieving of the petitioner full stop. Though this plea is opposed by Shri Manas Mani Verma, but looking to the fact that transfer was affected on 6/12/2022 after lapse of more than 14 months, relieving of the petitioner cannot be given a seal of approval. Transfer order as far as an petitioner is concerned is hereby quashed. Liberty is granted to transfer order and the relieving order are hereby quashed. Respondents will be at liberty to pass fresh orders looking to the administrative exigency of the matter.
Serial number 86. Serial number 86.
In this petition, I'm praying for a password, my lord. Mr. Divakar is on his legs. He has to argue the matter, my lord. He is on his legs before DB1, my lord.
पासवर्ड इसलिए नहीं हो सकता डीबी है मेरी 2:30 बजे 2:15 बजे से
My lord, the pleadings herein are.
वैसे भी फाइनल हियरिंग वाले दिन मैं पासवर्ड करता नहीं और आज डीबी है चलिएगा अब बाद में सुनाइएगा इसको लिखिएगा
My lord, the pleadings are complete, my lord.
It may be posted for next week because interim is prevailing, my lord.
हाँ ठीक है श्री आपका शुभ नाम बताइए
Aman Gupta.
Aman Gupta submits that arguing counsel is not available. He prays for Passover. Next para. Today Passover is not possible on 2 accounts. Namely, it's a final hearing day. And as per the convention followed by this court, on a final hearing day, there is no Passover. Secondly, today there is a special DB from 2:15 p.m. Therefore, request for Passover is hereby turned down. List on 17 फरवरी 2024 top of the list. चलिए with clear stipulation that no request for passover will be entertained. बता दीजिएगा उनको.
Serial number 88. Serial number 88.
Can't see the order dated 4 January 2024. Last office.
My lord, the re-verification report is available, my lord.
So,
क्या order है?
Regarding appointment of Anganwadi Karyakarta, I stated that the mark sheet submitted, which is that is directed to produce the report.
एक second. जी बताइए.
Sir, there were two reports, my lord. Therefore, my lord has directed the verification. It has been received.
क्या पाया?
These mark sheets are forged, my lord. Which has no. These are the forged mark sheets.
किसकी?
Respondent number 5.
5 की.
It has been received through email, my lord.
रिस्पोंडेंट नंबर 5 का नाम तो अंजलि यादव है
जी. मार्कशीट सब अंजलि के नाम से सबमिट.
और ये अंजलि के नाम से कैसे?
नहीं, इसी नाम से सबमिट किया मार्कशीट. मार्कशीट के नाम से मार्कशीट है ही नहीं.
अच्छा. और ये भी फोर्ज्ड है.
जी, और वो भी फोर्ज निकली.
देखिएगा. बताइए, आपको कुछ कहना है क्या?
So they may file this documents my lord with an affidavit my lord. I may verify. Because in the earlier my lord they filed the return my lord.
Copy of verification dated 9/2/24 handed over by the respondent state council be given to Shri Rajendra Kumar Shrivastava,
my lord.
Rajendra Kumar Shrivastava, who may verify the same. Let this document be filed along with the affidavit of the officer in charge by tomorrow with an advance copy to Shri Rajendra Kumar Shrivastava. He may file counter affidavit within 7 days. List this case in the week commencing 4 March 2024.
14962.
Serial number 90. Serial number 90.
But the respondents have made a request in this matter. This matter needs to be linked with the matter already pending.
Infructuous. I have filed an IA for dismissal.
But it
There
is
were,
not.
I will just make one line submission. There were 3 identical revenue cases in which applicant petitioner was common in all the cases that went up till commissioner. Commissioner passed 3 identical orders on same date. So he has filed 3 identical miscellaneous petitions. One has been finally disposed of. I have already filed the copy of order. Not every case now will have to follow that. Lordship is
order.
IA along with IA, not page 20. IA is 713 of 24 for dismissal. That is only submission.
IA
713 of 24, man.
पंखा चल रहा है.
And that order of coordinate bench is at page 20 of that IM.
Respondent number 1.
This order is to be followed.
My lords, just one contention.
आपकी
If my lord would appreciate para 2 of
आपकी
that order.
presence में तो किया है.
My lords, if my lord would just appreciate para 2 of that order.
हाँ पढ़े.
During that period of time, the second appeal against the partition order was already pending. That order, that appeal has already been decided.
Against him?
Against me?
Against him?
My lords, I have already preferred MP against that order. The coordinate one was pleased enough to stay the operation of that order. So my only contention is that the mutation orders have been passed in the light of the partition order. Now that partition order has already been challenged. So this petition may kindly be linked with that matter. Whatever would be the fate of that matter, my lord said.
एक सेकंड. Partition order आपने कब challenge किया?
My lord, the partition order has been, my lord, 1/2/2024 को ये हुआ है.
क्या हुआ?
Stay हुआ, my lord, that order that I just applied. That order was.
Partition order को जो आपका challenge था, that has been set at naught. अभी जो हमारे सामने केस है दैट इज इन रिगार्ड टू म्यूटेशन. नहीं एक सेकंड अपन समझ ले, समझ के कर रहे, कोई जल्दी नहीं है. आई एम नॉट गोइंग टू बी एनरिच्ड विद वन मोर डिस्पोजल. कोई फर्क नहीं पड़ता है. ठीक है, तो इशू समझ लीजिए आप. इशू क्या है? कोऑर्डिनेट बेंच ने क्या कहा कि जो आपके पार्टीशन में फाइनल ऑर्डर होगा, यू विल बी फ्री टू मूव एन एप्लीकेशन फॉर म्यूटेशन एज लॉन्ग एज दैट पार्टीशन ऑर्डर इज remaining as it is. The authorities, revenue authorities were not at fault in making mutation in terms of the partition order. Liberty भी दी है. अगर कल को partition order set aside हो जाएगा तो this liberty will continue in your. इसका इतना फैक्ट और लिख देते हैं. ये इनकी जो एप्लीकेशन फॉर डिसमिसल है ना, ये ऑर्डर लगा हुआ है विवेक जैन साहब का, IS 713/24. सेम ऑर्डर कर दीजिएगा, उसमें लास्ट में इतना लिख दीजिए. वो ठीक है, सेम ऑर्डर कर दीजिए. चलिए.
Lord sir, the para 2 would be required to
पैरा
change.
2 को थोड़ा सा चेंज कर दीजिएगा. चलिए. It is informed by the petitioner that his application challenging the order of partition has been dismissed, and against which he has filed MP number 359 of 24. Thus, all the rights and liabilities in regard to partition are to be decided in MP 359/24, and therefore all the entries in regard to mutation shall be subject to the outcome of MP 359/24. Chali.
Serial number 98.
Lordship, in this, the university has filed the reply, but Lordship, the UGC and the Government of India.
क्या मैटर क्या है?
Now, Lordship, issue is the applications are invited for the post of assistant professor paramedicals. Lordship, there are two branches where from that one is medical branch and one is non-medical. There was a stipulation that they should have a registration in the concerned council. Lordship, the selection committee was constituted of the consisting of the
Advertisement was issued by Dr. Hari Singh Gaur.
Yes, sir.
Central University.
Yes, sir, Central.
नहीं, UGC का क्या रोल है?
UGC सर इसलिए बेसिकली रोल है कि सर नॉन क्लिनिकल जितने भी सब्जेक्ट्स हैं, we don't have any council for their registration. Clinical paramedicals हो गया, MBBS, we have councils. So अब सर इन्होंने पहले एग्जीक्यूटिव काउंसिल ने अप्रूव किया, और उसके बाद जब इवन दो दी their statute say whenever there is any dispute to that effect, the matter will be sent to the visitor. Visitor is Honorable President of India. Without following this, they had conducted another executive council and said no, come with the registration. So that is
who's appearing for the UGC.
I'm okay. He's appearing. I'm appearing for you.
जवाब देना है आपको?
Yes, my lordship. Kindly give me 2 weeks time. I receive from today onwards, my lords.
Shri Deepak Avasthi, learned counsel for the petitioner. Shri
Aditya Rai.
Siddharth Shukla for the respondent number
3 and 4, sir.
3 and 4.
In both matters.
Shri Aditya Rai for respondent number 2. Shri Rai prays for and is granted 2 weeks time to file reply on behalf of respondent number 2. List after 2 weeks.
Yes, sir. Sir, any week commencing because 1 साल से ऊपर इनकी अपॉइंटमेंट
Week commencing 4 March 2024.
I see, sir.
Okay. Serial number 111.
Many petitions in second community matter in terms of judgment. Your lordship.
एक प्रेरणा के लाइट में है ये सर सेम ऑर्डर कर दीजिए रख लीजिए
Serial number 112.
Malord, the petitioners have cleared Malord net and Malord, they aspire for the post of assistant professor Malord, which has been advertised by the MPPSC Malord. Now Malord, white corrigendum Malord, annexure P2 Malord, the date was extended. And the date of exam was fixed at 28th of January Malord. Now that has been extended from 28th January to P2 Malord. P2 Malord.
अरे ये P2 तो पिन्नू चौहान है ना आपका केस
जी जी जी
P2 तो कोई हाई कोर्ट का ऑर्डर की कॉपी लगी हुई है 11488 ये कुछ और खोल रहा है
गलत है
P2 हाँ एडवर्टीजमेंट
एडवर्टीजमेंट Now, in this Malord, online आवेदन की प्रारंभ तिथि 30/11 और ऑनलाइन अंतिम आवेदन की अंतिम तिथि 15/12/23. Now, this was the first corrigendum Malord. This was issued Malord to accommodate the students clearing set Malord, as would be clear from.
ये तो एडवर्टीजमेंट है कॉरिजेंडम कहाँ है ये
corrigendum
शुद्धि पत्र अच्छा
शुद्धि पत्र इसका पैरा 2 देखेंगे तो इससे समझ में आता है कि सेट जो बच्चों ने क्लियर कर लिया उनको अकोमोडेट करने के लिए ये इन्होंने एक्सटेंड करी डेट
जी
now the present petition of the entire case is my lord that this post is advertised my lord after a period of almost 5 years my lord. The last advertisement was in the year 2018 my lord.
जी
Now this advertisement was initially issued my lord on 30th of December 2022 my lord. Then extended by this first corrigendum my lord to accommodate the students clearing set my lord.
What was the last date जो लास्ट डेट क्या थी उस फॉर्म में पहला एडवर्टाइजमेंट कब
पहले वाले में लास्ट डेट थी 31st of March 23.
कब कहाँ है वो एडवर्टाइजमेंट
P1 वो P1 है
जी
Now our case is my lord when for set students my lord the students clearing set
ठीक है इनका आपका जवाब क्या है Can you postpone the exam and issue corrigendum at any point of time?
My lord, this was only done to because there was the set examination is also conducted by MPPSC.
ठीक है.
And there was an option that was there that if
कहाँ किस नियम में है नियम तो बताइए थोड़ा प्रावधान तो बताइए.
The challenge is that they also want to participate in the examination.
Which who?
My lord, the petitioners also want to participate in the examination now.
Which examination?
This very assistant professor.
So are they barred from participating in the exam?
Because they at the time they were not having the qualification.
Petitioners attained qualification after this 31 March 2023.
My lord, the entire case is my lord. They have extended the date for submission of online forms my lord in view of the result of set my lord. Once they have done that,
Yoga means submission is that once that date has been extended, then anybody and everybody who's eligible up to the extended date should be allowed to fill the form.
No, my case is, my lord, that we have cleared net, my lord. Net exams were scheduled to be announced on 10th of January, my lord. And my lord, as per the last corrigendum, the last date for filling up of application form for the post was 12th of January. Then the result of net was not announced on 10th, my lord. It was announced on 17th or 18th, my lord. By that time, my lord, that date has gone, my lord. Therefore, my lord, our contention is when for set they have extended the date, my lord, for submission of online.
Can a candidate seek such extension? Under which provision of law you can seek such extension? कल तो फिर कुछ और भी एग्जाम होगा तो उसको भी एक्सटेंड करना पड़ेगा.
अभी एक और ग्राउंड ये है सर कि पहले है ना इनकी डेट ऑफ एग्जामिनेशन थी 28 जनवरी सेकंड कॉरिजेंडम के अनुसार. दैट डेट ऑफ एग्जामिनेशन दे हैव एक्सटेंडेड वाइड एनेक्सर P5 मतलब
P5.
Now that date has been extended to 3rd of March, my lord.
नहीं वो ठीक है.
Then they can very well allow these, my lord, particularly when the post is advertised after a period of 5 years. जब सेट के लिए एक्सटेंड कर सकते हैं तो नेट के लिए क्यों नहीं एक्सटेंड कर दिए? 2-3 दिन का डिफरेंस.
चलिए आने दीजिए जवाब, उसमें क्या दिक्कत है? Issued notice is waived by Shri Aditya Pachori. Let reply to the petition be filed within 10 days. List on within 7 days कर दिए. 7 days list on 21 फरवरी 2024. 21 नहीं, सॉरी 7 days बोला ना. 23 फरवरी 24.
Item number 15.
हैं?
It may be disposed of by
कौन सा?
learned premises preparing.
आइटम नंबर 74 में लिखिएगा. श्री कुशवाहा प्रेस फॉर विड्रॉल ऑफ दिस पिटीशन. अरे एक मिनट रुक जाइए, 14 भी देखो. 74 में लिखिएगा प्रेस फॉर विड्रॉल. अभय सिंह कुशवाहा प्रेस फॉर विड्रॉल ऑफ दिस पिटीशन. अकॉर्डिंग दिस पिटीशन इज डिसमिस्ड एज विड्रॉन. हाँ 14 नंबर.
So yes, proceed. He consenting with the considering that
petitioner's representations are pending before the municipal corporation.
14 नंबर में लिखिएगा श्री कृष्ण कुमार गौतम फॉर द पिटीशनर. दिलीप पांडे फॉर द रिस्पोंडेंट. आप लोग भाई भाई हैं क्या? अरुण पांडे, दिलीप पांडे. With the consent of Shri Pandey, who appears from Municipal Corporation Rewa, this petition is disposed of with the direction to the petitioner to submit fresh representation. 15 दिन, 45 दिन. This court has not expressed any opinion on the matter. Fully.
My matter is listed in item number 5, my lord. I am for the respondent in that.
5 of what?
Final hearing, my lord.
Final.
It may be kept in the list, my lord, because I am feeling backache, my lord, severe backache.
हाँ हाँ ठीक है चलिए. 124 बचा, क्या बचा? फाइनल 124 दीजिए. हाँ बताइए.
Item number 16, I have been promoted.
68.
16.
जी.
I have been promoted, but not from that date. I may be given liberty to file a representation.
लिखिएगा श्री सूर्य प्रकाश पाठक संतोष कुमार पाठक for the petitioner submits that petitioner has though been given promotion but not from the date from which he was eligible. He prays for withdrawal of this petition with liberty to file a fresh representation to the competent authority in regard to claiming seniority and preponement of the date of promotion. 15 दिन, 60 दिन. This court has not expressed any opinion on the matter.
Final hearing cases, serial number 124. K.K. Sharma,
चोपड़ा साहब अगर आधा घंटे में दोनों पक्ष कंप्लीट करें तो लीजिए, नहीं तो कोई भी फिक्स डेट ले लीजिए. उसका
पहले कर दूंगा सर.
ठीक है, आपका भी हो जाएगा ना?
आधे घंटे में नहीं हो पाएगा सर.
इसको रखा टॉप ऑफ द लिस्ट था, लेकिन अचानक डिवीजन बेंच आ गई. इट वाज इवन नॉट नोन टू मी कि डिवीजन बेंच पे जाना पड़ेगा. इसीलिए फाइनल हियरिंग में टॉप ऑफ द लिस्ट रखा था कि 2:15 से शुरू करेंगे, 4:30 तक खत्म कर देंगे.
आराम से 1 घंटा में. आधा घंटा सफिशिएंट टाइम.
आपके लिए है ना, इनको भी तो सुनना है.
इनके बाद तो कोई पेपर ही नहीं, सारा फोर्ज और फैब्रिकेटेड डॉक्यूमेंट और कंसेंट डील.
चोपड़ा साहब इसीलिए तो ज्यादा सुनना पड़ेगा. चोपड़ा साहब है ना? हाँ, इसीलिए तो ज्यादा सुनना पड़ेगा बिफोर रिकॉर्डिंग अ फाइंडिंग. आप ये बताइए कब आएंगे आप अगली बार?
थोड़ा अगर आप इस बार सुन लें
तो उसमें क्या याद नहीं
रिजर्व कर लीजिए.
नहीं रिजर्व की कोई बात नहीं है, याद नहीं रहता
क्योंकि हम अब सीनियर सिटीजन हो गए सर.
हाँ नहीं,
एक पीढ़ी हमारी निकल चुकी है सर.
इसीलिए तो आपसे पूछ रहे हैं आप कब आएंगे. अब आप
फिर फरवरी एंड में दे दीजिए कोई डेट से,
ठीक है।
क्योंकि इनका मेडिएशन वगैरह का भी कुछ नहीं हुआ।
28 फरवरी,
जी सर।
ठीक है, विद द कंसेंट ऑफ द पार्टीज एंड लुकिंग टू द, इनका शुभ नाम डालिएगा।
दिनेश चोपड़ा।
श्री दिनेश चोपड़ा in person. Shri Khare for the respondents due to paucity of time list this case under the same head top of the list on 28 फरवरी 2024।
इसमें सर रिस्पोंडेंट नंबर 4 जो है शुरू से नहीं अपीयर हो रहा, सब स्टार एब्सेंट है।
ठीक है, मत आने दीजिए, मत आने दीजिए।
और 340 की सर इन्होंने रिप्लाई अभी तक नहीं दी। 2 वीक्स का इनको टाइम दिया।
रुक जाइए, किसका रिप्लाई नहीं दिया?
340 सीआरपीसी का।
हाँ,
वो हम दे देंगे, पीडीएफ बना के भेज देंगे इनको।
कब दे देंगे रिप्लाई? श्री खरे प्रेस फॉर एंड इज ग्रांटेड 7 days टाइम टू फाइल
2 बार इनको ऑर्डर हो चुके हैं
टू एप्लीकेशन अंडर सेक्शन 340 CRPC with an advance copy on email of the petitioner on or before 22 फरवरी 2024। लिस्ट ऑन 28 फरवरी 24, टॉप ऑफ द लिस्ट। 28, 29, 28 को नहीं हो पाया तो 29 को पूरा कर लेंगे।
ठीक है सर।
ये 2 दिन के हिसाब से आइएगा।
ठीक है सर, थैंक यू।
चलिए रेगुलर लिस्ट से आइए।
पीरियड नंबर A1 डिटेल्स श्रीवास्तव,
ये कॉज लिस्ट नो आ जाता है। ठीक है, none for the petitioner. This petition is filed being aggrieved of an order dated 5/1/23 passed by the Executive Engineer, Public Works Department, Navadapuram. Rejecting his claim for grant of contributory pension. Issue notice to the respondents. Notice is waived by Shri Manas Mani Verma. Let reply be filed within 4 weeks. List thereafter.
पीरियड नंबर 8
None for the petitioner.
This is second visit of the petitioner before this honorable. Previously, this honorable court allowed the petition and set aside the impugned order. My lord, by the
Issue notice to the respondents on
my lord has already passed the order. My lord,
दिखाइएगा।
identical similar impugned order में इसी के साथ टैग भी कर दे। मेरा निवेदन है। इसका नाम जो है
सेम ऑर्डर कर दीजिएगा, लिस्ट अलोंग विथ कर दीजिएगा। चलिए 9 भी सेम है?
नहीं, सेम है मैम।
हाँ?
सेम है।
सेम है, 9 में भी सेम ऑर्डर कर दीजिएगा।
पीरियड नंबर A1 पीरियड नंबर A1 राकेश सिंह।
My lord, this is the second round of litigation. The order passed in earlier round is at page 20. The petitioner is an Anganwadi Sahayika, my lord, who got appointed on the white dated 30/6/2021. Private respondent has preferred a CM helpline complaint. And behind the back inquiry was conducted, my lord, and earlier what services were terminated, that were put to challenge in earlier round of litigation.
फिर क्या हुआ?
My lord, this single bench order was challenged by the private respondent by a review and subsequently in appeal. The appellate court, the order of appellate court is at page 27, my lord.
एक सेकंड, आपके अंक कितने थे?
सब हमारे अंक
रिकॉर्ड बुलाना पड़ेगा।
नहीं साहब, इस पे इशू सिर्फ वीपीएल कार्ड का है।
हाँ,
और
तो
अर्लियर राउंड ऑफ लिटिगेशन
रिकॉर्ड तो बुलाना पड़ेगा ना इनका।
माय लॉर्ड,
इलेक्शन का रिकॉर्ड तो बुलाना पड़ेगा। किस आधार पे आपका बीपीएल कार्ड नहीं माना इन्होंने?
My lord, I am caveator and I am filing reply, my lord. And I am
पढ़िए ना पैरा 4 में, तहसीलदार बड़वारा पत्र क्रमांक इतना इतना एवं पत्र क्रमांक इतने इतने द्वारा यह पुष्टि की गई कि श्रीमती आरती बाई पति देवेंद्र महोबिया का बीपीएल में नाम नहीं है
सर,
लेकिन तत्कालीन परियोजना अधिकारी बड़वारा द्वारा बीपीएल का 10 अंक देकर अवैध रूप से आवेदिका को, कहाँ है वो आपका बीपीएल कार्ड?
सर लगा हुआ
Annexure, एक रुक जाइए अभी,
पेज 32 देख लें साहब।
एनेक्चर
P4, it's along with the P4 documents, my lord. P4 के डॉक्यूमेंट्स पे पेज 32 पे मेरा लगा हुआ है।
P4, yes.
At the right, my lord, at the top, there is a serial number also mentioned 167.
Just a minute. Page 32.
32.
हाँ, किस तारीख को जारी किया गया ये?
साहब ये 2004 का दिख रहा है, 21/1/2004।
देखिएगा, petitioner's contention is advised order, impugned order annexure P1 dated 29/1/2024, project officer women and child development project
बड़वारा झरेला
district Katni has wrongly relied on the report of Tahsildar saying that BPL card in the BPL record name of the petitioner is not mentioned, whereas according to him he has enclosed copy of her BPL card as annexure P4 in which her serial number, khata number is mentioned as 167 and name of her husband Shri Devendra Kumar Mahobia is mentioned as the head of the family. Full stop. Thus, without giving any opportunity of hearing and to prove that the BPL card was validly available in favor of the petitioner as was issued in favor of her husband Devendra Kumar Mahobia, impugned order has been passed. Full stop. Let reply of the concerned Tahsildar along with the concerned collector along with the records of the BPL card as annexed by the petitioner along with annexure P4 be produced by the collector Katni. Similarly, the project officer will be obliged to produce the complete original record for perusal of this court. List this case on 1 March 2024. Top of the list.
Till then, my lord, I will permitted because they are not allowing me to.
Till then, parties to maintain status quo.
My lord, my parties has been joined the service.
Status quo तो
And my lord, my reply is ready और reply में annexure लगा हुआ है कि वो कार्ड लगे हुए हैं।
Respondent has authorities have granted appointment to the private respondent.
ठीक है.
Without I be permitted, my lord, till then. I be
नहीं, status quo, nothing else. चलिए.
Then some prior date will be granted.
No, this is the case of not counting of work charge service.
दीजिएगा petitioner's contention.
We also covered
It
case.
is work charge. दीजिएगा annexure.
This is covered case, my lord, by annexure P3.
Petitioner's contention is that his work charge services have not been counted by the respondents for the purpose of computing the qualifying service for the purpose of pension, and this case is covered by the ratio of judgment rendered in case of Mahesh Prasad Mehto versus Managing Director and others, decided in WP number 11372/14. So also decision of the coordinate bench dated 27/2/2017 passed in WP number 11755/14. Record. ये बस जो ऑर्डर लगा हुआ P3 जैसा वैसे डिस्पोज ऑफ कर दीजिएगा इसको. चलिए.
My lord, one thing I want to mention. They have already given this benefit. This is second round petition. They have not given this benefit to the petitioner.
It is submitted that
Annexure P6.
एक मिनट रुक जाइएगा.
Yes,
that petitioner in WP 11755 has already been extended this benefit by annexure P6, but same has yet not been given to the petitioner. Mutatis mutandis, benefit be, if there is no other legal hindrance, be extended in his favor within 45 days of receipt of certified copy. Sally.
Serial number 13 to Deepak Sahu, State.
This petition is filed seeking a direction to the respondents to consider and decide petitioner's representation against the order of suspension. Full stop. This petition can be disposed of with a direction to the किसको दिया representation आप?
Respondent number 5 DEO.
To the respondent number 5 to consider and decide the representation through a speaking order within 15 days of receipt of certified copy
In
of
the
the
light
order.
of the circular, that is P10, my lord.
In the light of the circular dated
P10, P67.
28 जनवरी 2013 annexure P10. 30 दिन कर दीजिए 15 दिन का 30 दिन.
Any specific time?
30 days.
Serial number 50. Lal Ganesh Singh Baghel.
None for the petitioner.
सर इसमें जवाब आया नहीं अभी तक
अच्छा
टर्मिनेशन के खिलाफ
2012 से जवाब नहीं दे पाए क्या बात है?
Chief, we are communicating to the office or not.
हैं? कम्युनिकेट किया फिर भी नहीं आ रहा. लिखिएगा श्री लाल ज्ञानेंद्र सिंह
I may be permitted 4 weeks time as the last indication.
हाँ हाँ. This Srimati Sonali Vishwas for the respondents. This petition is pending for 12 years. The state has not woken up to file reply. Full stop. Srimati Sonali Vishwas submits that despite communication, nobody is appearing for the state to file reply. Next para. On 26/2/2019, one Shri V.R. Pandey, government advocate, had appeared and was given 4 weeks' time as a last chance to file reply. Full stop. Thereafter, no reply is filed till date. Full stop. Subject to payment of cost of rupees 25,000 to be recovered from the Commissioner Health Directorate Health Services and not to be debited to the public exchequer. 2 weeks' time is granted to file reply, failing which Commissioner Health Directorate Health Services shall remain personally present. List on 1 March 2024.
Serial number 20.
हाई कोर्ट लीगल सर्विसेज कमेटी में कराइएगा.
Serial number 17. Parag Tiwari.
हाँ. जवाब नहीं आया अभी.
In fact, this case, my lord, where
नहीं मुझे तो ये समझ में नहीं आ रहा. कंप्यूटर देखिएगा ये पिटिशनर के डॉक्यूमेंट R1 R2 कब से मार्क होने लगे?
RP1 लिखा है, रिव्यू पिटीशन है सर.
ये रिव्यू पिटिशन है
जी
क्या?
सर.
अच्छा अच्छा. हाँ. हाँ ऑर्डर अंडर रिव्यू एनेक्चर P1.
P1 months. 24/1/2022.
हमारा ऑर्डर है क्या?
नहीं, आपका नहीं है सर.
यही तो बड़ा दुर्भाग्य है कि
Honorable Justice Dharmadhikari had passed this order.
तो फ्लक्चुअस हुई थी. कौन अपीयर हुआ था? जयदीप सिरपुरकर.
ये इनके लिए पिटिशनर के लिए मिस्टर पराग तिवारी.
पराग तिवारी. हाँ फॉर पिटिशन नंबर 9 and 12.
जी.
तो क्यों कह दिया कि इन्फ्लक्चुअस हो गई?
हाँ, ये एक्चुअली सर हुआ क्या है कि दिस वाज एन इंस्टीट्यूशन, प्राइवेट इंस्टीट्यूशन व्हिच वाज रिसीविंग 100% ग्रांट इन इट.
नहीं वो तो ठीक है
जी.
तो मानव विकास समिति हो गई. हम ये कह रहे हैं कि इन्होंने ऐसा क्यों कह दिया कि इन्फ्लक्चुअस हो गई?
दे
previous appointment.
हाँ, पराग तिवारी जी का एफिडेविट लाइए कि उन्होंने ऐसा स्टेटमेंट नहीं दिया था।
नहीं दिया था सर उन्होंने। उन्होंने ऐसा कहा था।
तो रिव्यू कहाँ से हो जाएगा?
मैं अगर एक सेकंड में सर थोड़ा सा ही बता दूं। Actually हुआ क्या, they were the employees of a private institution. There was a dispute, they were removed by the society. Subsequently, Manoj, by the orders of the Commissioner Public Instruction, the teachers were permitted to form a society under the provisions of grant in aid में सर उसमें provision है in 1978 के act में they can form the society. They formed a society, started running the institution. So these petitioners were मतलब appointed in that institution. तो वो जो पहले वाला जो चैलेंज था उनका, वो ये सोचते हुए कि वो क्योंकि पुराना चैलेंज अब नई सोसाइटी फॉर्म हो गई, दे गॉट फ्रेश अपॉइंटमेंट, सो दैट thinking that now they have got fresh appointment, therefore the old petition has been rendered infructuous. Now the subsequently when the second petition was dismissed, the order was challenged before the division bench. Division bench was of the view कि आपका जो पहले वाला टर्मिनेशन ऑर्डर है वो आज तक सेटिस्फाइड नहीं हुआ, you withdrew the petition.
कहाँ है डिवीजन बेंच का ऑर्डर?
डिवीजन बेंच का ऑर्डर है सर, well that was simply withdrawn with liberty to file the।
हाँ वो लिबर्टी तो दिखा
मैं सर
RP 6
RP 6
to file a fresh appeal. Liberty is to file a fresh appeal, not to
well,
seek review petition.
मैं सर I'm sorry वो Mr. Tiwari is not here.
हाँ ठीक है।
At request of the council for the appeal, the writ appeal is dismissed as withdrawn, will liberty to file a fresh appeal. Fresh appeal इसको withdraw इसलिए किया था कि वो review फाइल करेंगे फिर fresh appeal फाइल करें।
फ्रेश अपील अब डायरेक्ट अपनी डीबी का ऑर्डर है, फ्रेश अपील फाइल कर दीजिए आप।
वो जब तक ये ऑर्डर रिव्यू नहीं होगा मालूम
नहीं हम कह देंगे that nothing will come in way of filing the fresh appeal in terms of the order of the division bench. भाई अब नहीं, because I cannot supersede the orders of the honorable division bench.
नहीं मैं irrespective of मालूम में ignore this order.
नहीं और इसको इग्नोर नहीं किया जा सकता ना, क्योंकि this is available on record.
नहीं ये तो मेरे लिए सर this is the liberty to me to file the fresh appeal.
Fresh appeal, yes. not to file a review petition.
No, but I have a right to file that review petition. और उसमें सर इतना सा होना है because वो उन्होंने गलत withdraw कर दिया, तो वो in view of subsequent appointment।
चलिए issue notice on IA 3260/23 an application for condonation of delay on payment of PF for registered AD post within 7 days, returnable 4 weeks. 800 चलिए। Order annexure P6 will be explained that whether review is permissible or not in terms of order annexure P6 passed by the honorable division bench. Chali, next case.
Pidana number 15.
Seeking 1 week time to place NTC guidelines on record. NCT guidelines.
मेरे पास है वैसे।
क्या है बताइएगा ना।
गाइडलाइन मेरे पास है ना। कुछ बचा है?
बचा
क्या है गाइडलाइन में बताइए।
I have not gone through these.
अरे अभी पढ़ लेते, साथ में पढ़ेंगे ना, हम भी पढ़िए आप भी पढ़िए। लीजिएगा श्रीवास्तव जी गाइडलाइन लीजिएगा। आपने अंग्रेजी विषय के लिए गए थे।
एलिजिबिलिटी में जाएंगे साहब 3.2 में।
3.2
Candidates with at least 50% marks either in the bachelor degree and or in the master degree in science.
कहाँ पढ़ रहे हैं? Eligibility candidates with 50% in senior secondary or +2 examination or its equivalent from a recognized board are eligible for admission. क्या पढ़ रहे हैं? हाँ पढ़िए ना। 3.2 पढ़ रहे हैं ना?
मान लो।
हाँ।
Eligibility मान लो।
हाँ।
And if P1 is having मान लो below than 50%.
हाँ?
Below 50% मान लो।
ठीक है। नहीं, ये तो 10+2 में मांग रहे हैं ना 50% नंबर।
नहीं, पेज नंबर एनेक्जम P5 देख लें सर।
P5 यस।
इम्प्यून,
हाँ पढ़िएगा।
आइटम नंबर 37, नेम ऑफ द पिटिशनर।
37 यस।
बीएड 2009 में की गई एवं स्नातक में 50% से कम
हाँ ठीक है।
अंक है।
हाँ, और स्नातक का प्रावधान कहाँ है इसमें?
एलिजिबिलिटी कैंडिडेट्स विथ एट लीस्ट 50% मार्क्स आइदर इन बैचलर डिग्री।
आप कहाँ पढ़ रहे हैं? अब आपने जो हमें दिया वो दूसरा दे दिया क्या आपने? ये बाद में अमेंड हो गया है ये।
ठीक
सर, इसमें कई अमेंडमेंट्स हैं।
ये लेटेस्ट वाला था सियासत जी।
इसके बाकी पेज कहाँ है? दीजिए ना, पूरा कॉपी दीजिए।
जी साहब, वो वाला कंप्लीट है, उसी में है, उसी का पार्ट है साहब जो दिया था।
आपके 50% नंबर नहीं है। That's the end of the matter.
इनके रूल्स अलग गवर्न करते हैं सर। 2008 की स्टैट्यूटरी रूल्स हैं। My lord, give me time, my lord, I'll see to it whether there is contradiction.
Respondent's contention is that as per the gazette notification dated, क्या डेट है इसकी गजट नोटिफिकेशन की?
फ्रंट वाला दिया था आपको।
It's 22nd October 21.
22nd October 21. Minimum eligibility criteria for is to have a bachelor's degree with at least 50% marks or master's degree in science, social science, humanity. इतना next ये पूरा 3.2 लिख लीजिए। Petitioner since does not possess that qualification, therefore he is not entitled to, she is not entitled to the admission, appointment, to participation in the selection process, and therefore the impugned order does not suffer from any infirmity.
रिजेक्ट कर दिया इनका कैंडिडेचर।
Statutory rules में 45% है।
Shri Aditya V. Singh submits that in the statutory rules that for prescribed percentage is 45. He prays for time to seek instructions. On his request, list this case next week.
The recruitment rules are of 2018.
As statutory recruitment rules of 2018, it is 45%. चलिए पूरा कॉपी लेकर आइएगा वकील साहब, इससे आधा अधूरा मत दीजिए मेरे को।
Lord is keeping in the next week.
Next week.
Serial number 90. Gaurav Tiwari, Sham Soni.
My lord, on 13th evening, I have received the copy of reply, my lord.
And when did you receive the senior?
Just a few minutes. Not multiple documents not related to this case is in fact. So we seek to verify, my lord.
देखिएगा
4 weeks time में kindly.
अजय शर्मा लर्नेड सीनियर, अजय मिश्रा learned senior advocate, assisted by Shri Gaurav Tiwari, for the petitioner, Shri Ishan Soni for the caveator, Shri Mishra prays for and is granted 7 days time to verify the documents.
4 weeks time to 4 weeks because the cases, the documents are related to some different cases. Not
4
related.
weeks time to verify the documents. List on 15 March 2024.
But can it be 14?
15 मार्च मत करिए 14 मार्च कर दिया 14 मार्च 14 मार्च
जुडिशियल ऑर्डर में नाम मिल जाएगा सब घर वाले घुसते नहीं रहेंगे.
नहीं आपके पास पुलिस है, प्रशासन है, आपको कोई चीज नहीं रोक सकता.
Serial number 21. Let's into on.
ये नहीं है ना, ये 61 दे रहे. सरस्वती लास्ट ऑर्डर मतलब रिजॉइंडर के लिए टाइम मांगो.
None for the petitioner. On the last date, time was sought to file rejoinder. No rejoinder is filed till date. Petitioner's perusal of the petition reveals that some advertisement was issued for recruitment of computer instructor in for teaching in different for imparting instructions in the government higher secondary schools situated in the district schedule. Full stop. This advertisement was issued in the year 2023. Full stop. Petitioner's grievance is that though he is fully qualified and they hold requisite qualifications, had applied for the said post as was advertised by Annexure P1, but petitioners have not been selected. Hence, they filed this writ petition claiming the relief that respondents be directed to take steps to set aside the merit list made by the concerned respondent, whereby candidates having less integrated score were selected, and further to select the petitioner based on his score and counting his experience. Next paragraph. Respondents have filed a reply, and in their reply they have categorically mentioned that the petition is bereft of merit. Full stop. That petitioner's reliance on Annexure P6 is in regard to appointment of guest faculty and not in regard to computer instructor. Full stop. Guidelines for the appointment of computer instructor are contained in Annexure R1, R2 and R3, and petitioner has suppressed the relevant facts. Full stop. It is submitted that petitioner's name appears at a lower merit as is evident from Annexure R4, and therefore petitioner finding a lower place in the merit is not entitled to seek any indulgence. Next paragraph. Annexure R1 is the guidelines issued for recruitment of computer instructor These guidelines have been issued by the Directorate of Public Instructions on 4/5/2023. Full stop. According to these guidelines, applications for computer instructors will be invited through the portal meant for guest faculties. Full stop. Sorry. The candidate applying for the post should possess necessary GFMS portal generated scorecard, and in the scorecard, score of triple S-2-I.T panel is reflected. Full stop. In charge of the institute will download the scorecard reflected on GFMS portal and thereafter Annexure R2 provides the qualifications which are the desired qualifications for the purpose of recruitment of computer instructors. Similarly, circular dated 6/7/23 Annexure R3 clearly provides that only triple S-2-I.T scorecard bearers will be entitled for appointment on the post of computer instructors. Full stop. Thereafter, a merit list is available on record which reveals that name of Chandra Brahma Dev Singh is mentioned at
24.
serial number
24.
कहाँ है 24?
So ये
पेज नंबर
पेज नंबर 12 रिप्लाई का पेज नंबर 12.
23, 39 किस तरीके से नाम लिस्ट बनाई है?
तो सर ये सीरियल नंबर इधर है, ये मैरिट नंबर्स है.
सीरियल नंबर कहाँ दिए?
सीरियल नंबर, रोल नंबर.
सीरियल नंबर कहाँ दिए है? ये मेरिट नंबर है. सीरियल नंबर तो रोल नंबर है.
अच्छा, रोल नंबर है, ये मैरिट नंबर 37 होगा. मैरिट नंबर 37.
Merit number 37. At merit number 37, that means that there were more, there were persons securing higher merit, and when tested on this aspect, that nobody less meritorious than the petitioner has been given appointment, comma, and a merit list has been prepared on the basis of the basic score, comma, there is no illegality in the said decision of the authorities calling for interference. Petition fails and is dismissed. बोलिए.
आइटम नंबर 5 फाइनल हियरिंग लिस्ट
तो रहेगी नहीं, कितनी बार मेंशन करेंगे आप?
तो मेरे को लगा
My lord, I would like to withdraw item number 67 with liberty to file fresh, my lord.
67 लिखिए. श्री
सिद्धांत जैन.
जी
सिद्धांत जैन.
Siddhant Jain prays for withdrawal of this petition with liberty to file properly constituted petition.
That's 74. Merit
कर दिया.
So, 67.
Prior to that, they have made the payment.
ले लीजिएगा डॉक्यूमेंट ले लीजिए कॉपी दे दीजिए वो इलेक्ट्रिसिटी वाले मैटर में कौन अपेयर हो रहे हैं आप वो देख लीजिए आपने देख लिया ये
नहीं सर
दे दीजिए
वो अनडिस्प्यूटेड है, इनका नहीं है, वो वर्मा जी का है, हाईकोर्ट
नहीं 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 नहीं
इनको भी दे देते हैं कॉपी,
कॉपी दे दीजिए
लॉर्डशिप,
क्योंकि 3 मैटर है, एक वर्मा जी का मैटर है, एक रिकॉग्निशन जो नहीं दिया है बार काउंसिल ने उसको चैलेंज कर रहे हैं, तीसरा इलेक्ट्रिसिटी का मैटर है।
इलेक्ट्रिसिटी संबंधी है कि दे हैव ऑलरेडी मेड द पेमेंट इन अर्लियर स्टेज।
ठीक ठीक हाई कोर्ट एडवोकेट्स बार एसोसिएशन
हाई कोर्ट नो एमपी हाई कोर्ट,
अच्छा
हाई कोर्ट एडवोकेट का तो दे ही रहे थे, ये अनडिस्प्यूटेड है, इनने कोई स्टेटमेंट यहाँ नहीं दिए,
जी
दे आस्क फॉर कनेक्शन एंड दे मेड द पेमेंट, फर्दर दे स्टॉप द पेमेंट एट द टाइम ऑफ फाइलिंग दिस पिटीशन।
ठीक
Sir, in this matter, state has also filed an affidavit, probably in terms of some directive issued by my lord, wherein they've given a chart pertaining to various districts in the state of Madhya Pradesh, wherein some they are providing,
you are
some they are
dealing
not.
with WP 18637
18637.
जी कब फाइल किया है स्टेट ने?
Yes, sir, last week. Yeah.
5 फरवरी को आईए का नंबर है
36 एफिडेविट जो है थैंक यू क्या है एफिडेविट में?
सब इसमें एक लिस्ट इन्होंने दे रखी है, कुछ जगह कहीं बताते हैं कि इंफॉर्मेशन जैसे इन्होंने गैदर की है, स्टेट फाइल करता है इसको,
क्या
कि कुछ जगह कुछ डिस्ट्रिक्ट बार्स में दे रहे हैं, कुछ में नहीं दे रहे हैं।
ओके
शूटर स्टेट में दे
हैं
इससे भी सर एफिडेविट में सर पैरा 4 पैरा 6 इंपॉर्टेंट है,
पढ़िएगा 4 5 6 पढ़िएगा
सबमिट करके एप्लीकेशन कोऑर्डिनेटर
कहाँ है पहला 4
पैरा 4
ये एफिडेविट जो है अंडर सेक्रेटरी का वो मिस्टर उमेश पांडव का इसमें तो पैरा 1 2 उसके बाद 7 आ गया 7 8 9 10 कहाँ से शुरू हो रहा है?
तो मेरे पास
एक सेकंड नहीं आप प्लीज
तो मेरे पास भी
नहीं ठीक है एक्सेल अप्रोप्रिएट कोऑर्डिनेशन नहीं देखिए ना स्कैन नहीं हुआ लगता है
तो मेरे पास है
जी दीजिएगा प्लीज जी पैरा 4 पढ़िएगा प्लीज
that primarily seems that annexation RR1 that various are not paid by this program. That as per the declaration made by the
पेड नहीं है सही पढ़िए उसको इलेक्ट्रिसिटी बिल्स आर नॉट बीइंग प्रोवाइडेड बाय द स्टेट गवर्नमेंट
that as per the declaration Central states the place where the litigants of its clients are located is being paid by the state government. For that it is respectfully submit that earlier when is chairman has approached this honorable court by filing writ petition number 4 to PIL registered at so copy of memo of writ petition was annexed and thereafter in terms of the order passed by the honorable Supreme Court the said PIL was disclosed.
क्या है उस पीआईएल में RR3 देखें जरा
सर RR2 में सर मेमो लगा है
RR2 में मेमो ऑफ
writ petition उसमें जो रिलीज शॉर्ट था वो इंटरनल पेज 13 में आ रहा है
जी
the respondent number 1 and 2 were kindly directed to exempt the bar association to oversee the whole of the Madhya Pradesh from payment of electricity bill and the respondent number 1 be directed to make good the electricity bill monthly.
जी फिर क्या हुआ उसमें
ये पिटीशन डिस्पोज ऑफ होगी तो सर एनेक्शन RR3 से
RR3 पढ़िएगा
2014 से सुप्रीम कोर्ट का ऑर्डर SLP का सब कोर्ट करके उसी लाइन पर डिस्पोज
क्या है कोर्ट तो पढ़िए
ऐसा देखा है when a counsel for the respondent number 2 has invited our attention to the order passed by the Honorable Supreme Court dated so and so in SLP number here. So the same reads as thus, upon hearing the counsel, the court has made following order. By order dated 25/7/23, the Government of Madhya Pradesh Department of Law and Legislative Affairs communicated to the Working Secretary Madhya Pradesh State Bar Council as follows. Subject to the hearing number so and so made by the Honorable in the Adivasta Panchayat for payment of responsibility in relation to aforementioned subject. It is most respectfully submitted that the furtherance with the announcement number so and so, the proposal pertaining to payment of electricity bill of case by sitting of the client in the court compound of the converted will be examined with Chief Minister in Adivasta Panchayat, the state government after examining the already allotted so and so to the Honorable High Court by departmental memo dated so and so. Counsel for the parties agreed that the special leave petition may be put in terms of the opposition. And the prayer made by the counsel for the parties is fair and reasonable. It is observed that the order of the High Court is rendered unnecessary in the protection.
ये पेज 6 पर आइएगा, पेज 6 में इसी एफिडेविट के ये क्या है ये?
एक्चुअली ये जो डिस्ट्रिक्ट कोर्ट का हाई कोर्ट का है पूरा स्टैब्लिश कौन से काफी एक्सपेंडिचर रिएम्बर्स होता है स्टेट गवर्नमेंट। तो सर हमने हाई कोर्ट से इंफॉर्मेशन सीख करी कि डिस्ट्रिक्ट कोर्ट और तहसील बार एसोसिएशन में पेमेंट इलेक्ट्रिसिटी बिल का कैसे रिएम्बर्स।
तो क्या क्या है इसका क्या?
सर मतलब ये ऐसा जैसे अलीराजपुर है सर, इसमें डिस्ट्रिक्ट हेडक्वार्टर में सर तो एस्टैब्लिशमेंट का जो रिएम्बर्समेंट का नंबर है ना उसमें भी शूटर शेड का पेमेंट ये कर रहे हैं।
ऐसा कहाँ लिखा है आपने? यही तो समझना चाह रहे हैं हम। रिमार्क करके लिख दिया, अपना इतना आधा अधूरी जानकारी से कैसे काम चलेगा?
बल्कि ऊपर लिखा है इन्फॉर्मेशन वेदर पेमेंट
ऑफ इलेक्ट्रिसिटी बिल ऑफ डिस्ट्रिक्ट बार एसोसिएशन आर मेड बाय डिस्ट्रिक्ट एस्टेब्लिशमेंट। तो आप तो ऊपर बार एसोसिएशन लिख रहे हैं और यहाँ शूटर सेट बता रहे हैं।
सर ये मैंने
नहीं, बात करने से नहीं होता है, कागज से होता है। आपकी बातचीत को हम नहीं लिखेंगे क्योंकि आप तो कल जाके पलट जाएंगे वहां पर। आपकी बातचीत को कैसे माना जाएगा? Is your secretary understand that what he is writing and before which court he is writing what? Does he understand the sanctity of the High Court? क्या क्या कागज बनाया है ये? अरे भाई आपको कहाँ लिखा है आपने कि हाई कोर्ट से मिला है? चलिए बताइए कहाँ आपके एफिडेविट में कहाँ लिखा है कि हाई कोर्ट से मिला है? फिर हम हाई कोर्ट के रजिस्ट्रार जनरल को बुलाते हैं अभी। हाँ पढ़िए, पैरा 4 पढ़िए। वेयर इज जी क्या लिखा है इसमें? इसमें लिखा है संलग्न पताका ए अनुसार आपकी ओर संलग्न प्रेषित है। कहाँ है पताका ए? कहाँ है पताका ए? कहाँ है पताका ए? इज फ्लैग ए। वेयर इज फ्लैग ए? वेयर इज इट मेंशन्ड ऑन पेज 6 that is part of this communication and is flag A? अरे भाई नहीं, एक बार क्या कंफर्म करेंगे आप? आप सिर्फ टाइम वेस्ट कर रहे हैं कोर्ट का। कहाँ है? इसको ट्रू कॉपी तक नहीं करने का जहमत उठाइए। अगर आपके सेक्रेटरी लॉ को ये नहीं मालूम है कि एफिडेविट के साथ जो डॉक्यूमेंट्स है उनको ट्रू कॉपी करना है, कहाँ है नोटरी की सील इसके ऊपर? दस्तावेज सारे नोटराइज होंगे, उसके ऊपर क्रॉस सील लगेगी। सिखाना पड़ेगा क्या ये आप लोगों को कि बंद हो गया आजकल? डॉक्यूमेंट्स पे आजकल लगना बंद हो गई क्या?
बंद हो गई। टीसी काउंसिल की होती है, पहले एक जुडिशियल
या तो टीसी काउंसिल ने भी नहीं किया है। सरकारी काउंसिल की जो लॉयल्टीज हैं वो डिवाइडेड हैं। आई विल नॉट एडजॉर्न द केस, लेट इट बी, वी आर नॉट गोइंग टू एडजॉर्न द केस। यू मे सीक क्लैरिफिकेशन। आप इसको टीसी करिए, अपना पूरा साइन करिए, पूरा नाम लिखिए इसमें। ठीक है, yes.
Sir, मेरा इसमें से submission था कि this information which has been provided,
जी.
we will presume, my lord, because it says the जिला विभाषक संघ के बिजली बिलों के भुगतान के संबंध में, that was the query, और ऊपर भी लिखा है. Some places they are providing, some they are not providing. Our information is on the basis whereof we are in the process of verifying and asking from the respective bar associations also. And we are finding that many places where they are saying that it's not being provided. Still, my lord, nobody is paying, and the establishment.
Nobody is paying is different.
So we will also, my lord, put up after verification. We need some time to respond to this.
कब देंगे respond?
But it will take 15 to 20 days, my lord, to collect all this information. There are 50 districts they have given me the
नहीं, once they are saying something, then either it is correct or it is incorrect.
Say on affidavit, my lord, for example, if they are saying at Anuppur, Ashok Nagar,
आज की तारीख में ईमेल का और व्हाट्सएप का जमाना है.
तो फिर भी सब कुछ समय लगेगा.
3 days time to do the.
3 दिन का.
उससे ज्यादा नहीं देंगे.
3 से ज्यादा.
उससे ज्यादा नहीं देंगे.
कम से कम सर आपको एक 10 दिन का समय.
नहीं दे पाएंगे.
ये 50 जगह से.
हाँ, 50 जगह में 50 फोन कॉल, 5 मिनट का एक फोन कॉल भी लगा ले, क्योंकि होता नहीं. 2 मिनट का एक फोन कॉल, 100 मिनट.
हम लोग
100 मिनट मतलब 3 घंटे 20 मिनट. 3 घंटे 20 मिनट मतलब एक दिन का काम.
जी, रिस्पांसिबली सर, वहाँ जो रिस्पांसिबल.
नहीं तो रिस्पांसिबल क्या, बार के सेक्रेटरी.
We'll be giving that on our affidavit.
हाँ, बार के सेक्रेटरी को फोन नहीं तो करना, प्रेसिडेंट के सेक्रेटरी को. वो सारी डायरेक्टरी में नंबर लिखे हुए हैं. 3 दिन का समय. अरे आप रुक जाइए ना, आप बीच में क्यों? आपके साथ प्रॉब्लम क्या है रविंद्र जी, कि आप जो है इशू में आप बैठ जाइए. आपका झगड़ा है उनके साथ में रिकॉग्निशन को लेकर. वहां जब आएगा मैटर तब बताइएगा. They are seeking separate recognition from the bar council. You are opposing it. You say that you had also applied and you had withdrawn because there cannot be any segregation or separation of bars. This is your case. वहां जब आएगा तब आप बोलिएगा, अभी हर केस में मत बोलिए. जी भाई प्लीज बैठ जाइए. अभी नहीं सुनेंगे आप. अभी नहीं सुनेंगे आपको.
सर मैं थोड़ा सा प्लीज.
हाँ तो 3 दिन का समय देंगे. 3 दिन.
मेरा निवेदन ही है सर.
16, 17, 18 4 दिन ले लीजिए. 20 तारीख को सुनेंगे. हाँ अभी अरे एक अभी से इलेक्ट्रिसिटी की. हाँ ठीक है, अभी रुक जाइए. कहाँ है आपकी इंटरवेंशन एप्लीकेशन?
Since day one, I have been treated as an intervener, but no formal order was passed.
अरे भाई तो
This
कहाँ है?
last 1 year, Your Lordship.
हाँ बताइए ना, कहाँ है आपकी इंटरवेंशन एप्लीकेशन?
Your Lordship, it is 3202/23.
3202
It was filed on 17/3.
3802/23. क्या है बताइए, क्या है आपकी इंटरवेंशन एप्लीकेशन?
Your Lordship, my submission is this petition under Article 226 is not maintainable because disconnection of electricity bill, they are having alternate remedy, Your Lordship.
ठीक है, चलिए कंसीडर करेंगे आपको. अभी फर्स्ट ऑफ ऑल लेट देम वेरीफाई द डॉक्यूमेंट्स व्हिच आर फाइल्ड बाय द स्टेट गवर्नमेंट.
Your Lordship, one necessary thing I would like, I find out from the website of the High Court. May I put it?
हाँ बताइए बताइए.
सर ये रजिस्ट्रार जनरल जो मनोहर ममतानी साहब है, इन्होंने एक सर्कुलर निकाला था
जी
चैम्बर्स के बारे में भी और इलेक्ट्रिसिटी के बारे में.
क्या है दिखाइए.
ये ना तो हाई कोर्ट ने बताया रिप्लाई में, ना तो किस सरकार ने बताया.
एक कॉपी आपको भी दीजिए. जी क्या
ये मैंने वेबसाइट से निकाला है सर.
हाँ बताइए प्लीज बताइए.
इसमें इनका कहना है कि सब अपना अपना बिजली का खर्चा वहन करेंगे सर, सब एसोसिएशन, और ये डिस्ट्रिक्ट जज के सुपरविजन में चलेगा ये सब काम.
दिखाइएगा इसको.
और इसके अलावा सर लास्ट पेज में लिखा है जो मेरे केस में काम का है, 1 person 1 chamber 1 court complex.
नहीं अभी बिजली की बात कर रहे हैं. बिजली की
बता दे रहा हूँ, दोनों में काम का है.
हाँ
और
बिजली से संबंधित कौन सा पैराग्राफ है?
Your Lordship,
पैरा 6 पढ़िएगा.
the space to bar association shall be allotted on the condition that they shall be responsible for its proper maintenance, and they shall have to take their own electricity and water connection. And they shall also be responsible for the payment of electricity, water charges, and any other charges arises due to consumption of the members of the bar.
16
ये सर 19, 12, 16 का सिग्नेचर क्या हुआ?
ठीक है. Yes. जी. ठीक. ठीक है. आप ये बिजली वाले में दे दीजिए, मंडे तक फाइल कर दीजिए, इसको ट्यूसडे को सुनेंगे बिजली वाले को. लिखिए, ये कौन सा है? डब्ल्यूपी इलेक्ट्रिसिटी वाली कौन सी है?
18637 of 2015.
18637 ऑफ 2015. ठीक है. ठीक. श्री मनोज शर्मा, लर्नेड सीनियर एडवोकेट, असिस्टेड बाय श्री राजमणि मिश्रा for the petitioner, Shri Mukesh Agarwal for the Electricity Board, Shri Satish Verma for the intervener, Shri Swapnil Ganguly for the state. Next paragraph. Shri Ganguly has filed some affidavit wide IA number 36 of 24 filed by one Shri Umesh Pandav, Secretary Law and Legislative Affairs Department, enclosing therewith some information received from the High Court wide memo number A/1167 Jabalpur dated 2nd February 24, addressed to the Principal Secretary of the Department and sent by one Shri Santosh Prasad Shukla, Registrar within bracket District Establishment bracket close. But neither the information bears the seal and signature of the concerned officer, certifying it to be the true copy of the communication, nor there is congruence in the information sought from the heading of the document as available on page 6 of the affidavit. Full stop. Next paragraph. Page 6 of the affidavit starts under the heading Information whether payment of electricity bill of District Bar Association are made by district establishment. Information से district establishment तक inverted commas में ले लेना. Whereas Shri Swapnil Ganguly in his oral submissions submits that wherever word yes is used for different districts, their state or the district establishment is making arrangement for payment of electricity bills only in relation to suitor shades, whereas the heading is in regard to District Bar Association. Therefore, there is an ambiguity in the information furnished by the State Council and the submissions made by the State Council orally. Let additional affidavit of the Secretary of the Department be brought on record with all the documents which may be certified as true copy by him with his full signatures, name and designation and seal of the department. In the meanwhile, Shri Manoj Sharma, learned senior advocate, prays for and is granted 3 days time to verify the information so furnished by the state from the respective bar associations, which are 50 in number. Full stop. Let necessary information to counter the affidavit of the Secretary Law and Legislative Department be brought on record by 19th February 2024. List on 20 फरवरी 2024 at 2:15 PM. चलिए अच्छा सुनिए एक चीज और लिखिएगा. In the mean, Shri Mukesh Agarwal submits that Madhya Pradesh High Court Bar Association Jabalpur as well as Madhya Pradesh High Court Advocates Bar Association Jabalpur have taken connection for the electricity and they were paying the bills regularly till the filing of these petitions, and in support produces the copy of the bills and payment received the documents. Full stop. These documents are taken on record. चलिए अच्छा इनका भी नाम डाल लीजिएगा, रविंद्र गुप्ता जी का भी नाम डाल लीजिएगा.
डॉक्यूमेंट मैंने पेश किया सर.
लिखिएगा. अच्छा एक चीज और लिखिएगा. श्री सतीश वर्मा has produced a policy document regarding construction of advocate chamber at the district court premises in the state of Madhya Pradesh, as was issued by the then Registrar General Mr. Manohar Mamtani, who was Registrar General of the High Court of Madhya Pradesh. That document, copy of which is supplied to Shri Manoj Sharma, learned senior advocate. This document is also taken on record. लीजिएगा इसको भी. 1.1. इसमें 1 में आप नहीं है, बिजली वाले में.
नहीं सर. 1.1.
ओके.
क्या है
सर अपना जो मैसेज वाला
प्यार है
जी.
जी आपसे कुछ पूछा था पिछली बार.
We have filed that affidavit.
ये देखते हैं उसको.
It is number is not very legible.
जी 5193 ना.
1711 notes. आइए नंबर 17.
एक सेकंड खोले तो एक सेकंड रुक तो जाइए. खोले तो ये
1.19.
फाइव 5194 कहाँ चला गया. हाँ कब फाइल किया आपने एफिडेविट.
अच्छा
कब फाइल किया आपने एफिडेविट.
No, this is
एडिशनल रिटर्न.
yes, additional return in light of order dated 24/8/24.
Please find the attached corrected additional return on behalf of the respondent number 1 in the light of the order dated reply.
Yes.
लिख लीजिएगा 2005 का 5 SCC 181। लीजिएगा 2018 का 8 लिख लीजिए 2018 का 8 SCC 396 और 2018 का 1 SCC 196। फॉर्म क्या है इसमें? आपने 2018 का एक कोट किया है सर। सच रिफॉर्म्स such reforms in the administration of justice are not limited इतना speedy but also include reforms on the administrative side of the legal system as well.
Yes, ma'am. And there are to not, I have quoted the relevant parameter.
हाँ वही पढ़ रहे हैं इसीलिए तो पूछ रहे हैं आपसे।
जी सर। The Lordship may read further, Lords, toward the middle of that quotation. Such reforms in the administration of justice are not limited to the judicial aspects. That is how cases need to be decided, case management and court management, speedy disposal, etc. But also include reforms on the administrative side of the legal system as well. Procedural reforms and implementation thereof is an integral part of the judicial system. The ultimate purpose is to dispense justice, which is the highest and noblest virtue. Again, in this role, the Chief Justice gets authority and responsibility for administration of the court, which gives him the ultimate authority for determining the distribution of judicial workload. But this was in the context of the roster, actually, in which not the Honorable Supreme Court not delve into other factors also regarding powers of the Chief Justice, administrative powers. That is one. Lord, I am relying on one more decision. In fact, two, Lords. One is 1997. I am supplying copies, Lords. Seven SCC 463, Lords. 463.
एक कॉपी इनको भी दे दीजिए।
I am having only one copy. I'll supply later on. In fact, he has not supplied us with any judgment which he has cited.
No, Your Lordship, that day I have given
submitted a whole, just a moment, let me finish. He has submitted a whole compilation, Lords. He has not been served a single copy. So I'll give it to you, don't worry. This matter is not finishing. Lords.
You being a High Court, you can be more magnanimous.
Lord, High Court not supposed to be, but then not reality is quite different from. I need not say so.
I will give, I'm having just opposite judgment.
There's a lot of austerity.
आपका chance आएगा.
Your Lordship.
See, this is not the way to argue. Let him finish. Let him complete. Then you will have a chance. You can always rebut whatever.
In that case, I would like to start with not questioning the petitioner's locus notes. Because when the original...
आप अपना don't get distracted. आप जो कह रहे हैं वो बताइए. पहले ये 1997 में क्या लिखा है ये बताइए.
So 1997, Lords, this is on the question of judicial review of administrative action, Lords. Basically, starting from para 10, Lords. Para 10 onward, Lord, is mostly on the point. But the position has been summarized in para 31. And a lot of some English case law, etc. has also been discussed. And that eventually, Lords, if your Lordship will come to para 31, where not the position is summarized. 31.2, Lords.
Yes, just a minute.
And Lord, this judgment, in fact, Lord, relies upon one earlier judgment, Lord, which they say is the earliest judgment on the point. I would supply copies of that also. That is 1987, 4 SCC. Page 611.
दीजिएगा.
Page 6.
11.
611.
Sir. Yes.
Lord, there is one recent decision, Lords, of the year 2022.
नहीं इसमें क्या बता रहे हैं?
Lord, this is basically not on the point of judicial review of administrative action.
जी.
For that purpose, I am placing the plan. I think it is the penultimate paragraph, Notes, in 87.
So his contention is that a bar room could not have been allotted in favor of High Court Advocates Bar Association. That is the crux of his petition. That the action of the Chief Justice, the then Chief Justice, in allotting a bar room in favor of a newly created bar association was not called for. So by citing this judgment, you are supporting the action of the then Chief Justice that he was right in, and that decision cannot be called in question. This is your contention.
But that administrative decision.
Administrative decision.
Yeah.
That,
in fact, before that, I would question the petitioner's locus also. Because when the original body, the petitioner, being a PIL person, he is seeking to espouse the cause of members of the MPSCBA by saying that those people are not given access, etc. Not MPSCBA is very much a party. The purpose of a PIL is not, as we have not, as the law is evolved, that it is only not for upliftment of the downtrodden and so on and so forth, who can't afford lords to come to the courts. MPSCBA, I don't think it is in any way not falls in that category. They are very well competent to espouse their own cause. And not in that context, 1981 Supreme Court Lords, Supreme Court says in SP Gupta's case.
आपके रिटर्न में सब प्लीडिंग्स हैं ये सारी.
So return में ये लिखा है कि PIL is not maintainable.
ठीक.
That basic stand we have taken. That is, I don't want to use all those, not the interloper and busybody and all that, but then what we have said that the PIL is not maintainable.
Right.
Not para 25 of SP Gupta's case note.
दीजिएगा. कॉपी लाए हैं क्या?
I'm sorry.
लिस्ट दी आपने.
In fact, this book just came to me. Volume Lords. This is the first judge's case.
First judge's case. Yes.
In this case, not the petition was filed by the Bar Association of Bombay against transfer of judges.
Yes.
So in that context, the petition was filed. And not the judges, in fact, themselves had not approached, not taken any action for cancellation of the transfers. No, not this PIL was filed. In that, not the question of locus came up. Not so. Here, not in para 25, what they say.
And you see,
in fact, it starts from para
concept
20.
of transfer is an individual
Yes.
employee versus the employer.
Yes.
Here the issue is that whether creation of another body
Yes.
within the premises of the same High Court
Yes.
and then allotment of space to appease them.
No, their contention is that it is that this allotment falls in the definition of largesse. We say it is not a largesse.
Okay.
We have not derived any profit from that. It is basically not that.
So you are referring to which paragraph?
Para 25 not. In fact, not. It will start from para 20, but 25 is relevant insofar as by this submission is concerned that this such a litigation cannot be foisted upon somebody else.
Achha.
When the primary injured person is not interested in prosecuting, how then somebody else can prosecute on his behalf? This para 25 notes.
So have they said that they are not interested in prosecuting?
Whom not? Sorry.
High Court Bar Association, Mr. Sanjay Verma, has he taken a stand that
petition file करी नहीं सर इनके खिलाफ इनको गलत स्पेस अलॉट हुई है ये आ रहे हैं उनकी तरफ से कहते हैं कि साहब इनको गलत स्पेस अलॉट हुई है इससे इनके मेंबर्स का के राइट्स का हनन हो रहा है
पढ़िएगा पैरा 25 पढ़िएगा.
In fact, I did not want to argue all this, but then since not my learned friend has.
But let the stand of the High Court be clear.
Yes, no.
Why so much of ambiguity in the stand of the High Court? In the first petition also, we found that there is an ambiguous stand. On the one hand, they are producing the documents to say that which of the bar associations have been given free electricity, and then the counsel for the government appears and says that no, it is not the bar association, it is the suitor's state. So why so much of ambiguity in the stand? Either you say that you are supporting the petitioner or you are opposing the petitioner. If you are opposing the petitioner, then that means that you justify the creation of another bar association and allotment of space to it. And then we will give notice to you in the matter of electricity also that what is your stand in regard to supply of free electricity to the bar association. You will have to come out with your stand.
Electricity, although I'm not there in that matter.
I'm giving you notice so that you can file your reply by 19th.
I will convey. I'm here only as a.
प्रजापति जी को बुलाइएगा. हाँ, क्योंकि ये एम्बिग्विटी जो है आप लोगों के स्टैंड में इसको तो एक्चुअली हो ये रहा है कि आप लोग तो जो है एक दूसरे को जो है सपोर्ट कर रहे हैं और सब मतलब वी आर एट ट्रायल.
Generally, my lord.
We don't want to be on trial. We want to decide the issues. Let trial be contested between the parties and let us decide the issues. This way, that way, whatever we understand.
This is
but your stand should be clear. High Court's stand is not clear.
Stand is very clear. In this matter, our stand is very clear that the Chief Justice is not fully competent. He has the inherent authority to make there is a allocation for the bar council. There is allocation of space for the Advocate General's office. There is allocation of space for a canteen. XYZ, there are so many allocations. Nobody is questioning those. Here, he probably has a vested interest. He comes forward to say that so-and-so is being given space just because he is not given entry in there.
Yes,
of course. That is it.
Verma ji, personal allegations पे agitate मत करिए, सुनने दीजिए, please have patience. हमारे ऊपर भी एलिगेशंस लगते हैं, मगर एजिटेट होगा तो यहाँ से छोड़ के थोड़ा ना चले जाएंगे. अरे प्लीज सुनिए, जवाब आएगा जब मौका आएगा, जवाब दीजिएगा. उसमें लिखिएगा हाई कोर्ट काउंसिल श्री B.N. Mishra is requested to seek instructions as to what is the stand of the High Court in the light of the affidavit filed by the Secretary Law, namely Mr. Umesh Pandav, filed by the learned Deputy Advocate General Shri Swapnil Ganguly, informing the court that the information which was received by him by the state from the High Court is being shared with the bench. Full stop. Let High Court appear and take a categorical stand as to what is the policy of the High Court in regard, as a guardian of the district courts, in regard to supply of free electricity and making payment of the electricity bills to various bar associations across the state, and whether the cost of establishment of the High Court and the District Court establishment includes the cost of electricity bills to be supplied to the bar associations or other appropriate private spaces, private or public spaces. Let reply be filed by 19th. List on 20th वही रहेगा. चलिए.
मिलो.
इसमें मनोज शर्मा साहब एक कॉपी दे दीजिएगा पिटीशन के को आज दे दीजिएगा.
Minutes. So I was referring to para 25.
No, 25 of SC Gupta, yes.
Yes,
SP Gupta.
SP Gupta.
Yes.
आपके पता. In fact,
इसके पैराग्राफ अलग अलग हो जाएंगे. ये AIR है. अच्छा, जी.
The discussion note, in fact, starts from para 20, but I am referring to para 25 note. I will not read the entire complete thing. 25 note. Before we part with this general discussion in regard to locus standi, there is one point we would like to emphasize, and it is that cases may arise where there is undoubtedly public injury by the act or omission of the state or a public authority, but such an act or omission also causes a specific legal injury to an individual or to a specific class or group of individuals. Now, I'm not here. I would like to pause. That class or group of individuals whose right is sought to be espoused in this petition, they are not coming forward. They are not downtrodden. They are not socially backward. They are fully competent to come before the Honorable Court, invoke its jurisdiction and seek a relief. They are not coming. No, I'm not. Further. In such cases, a member of the public having sufficient interest can certainly maintain an action challenging the legality of such an act or omission. But if the person or specific class or group of persons who are primarily injured as a result of such act or omission do not wish to claim any relief and accept such act or omission willingly and without protest, the members of the public who complain of a secondary public injury cannot maintain the action, for the effect of entertaining the action at the instance of such a member of the public would be to foist the relief on the person or a specific class or group of persons primarily injured, which they do not want. So, notes, MPHCBA is the affected person, going by what my friend says and what the petitioner says. They have not come forward. No, this is a deliberate attempt to foist a relief on them. In their garb, in fact, this litigation is being, this PIL, is complete misuse of this Honorable Court's jurisdiction. So, this is so far. There is one more decision. I have the extracts of those paragraphs. I will just pass them. In fact, that's a very voluminous decision. I have the extracts.
हाई कोर्ट में क्या फाइनेंसेस नहीं है फोटोकॉपी कराने के लिए?
सर वो 600-650 पेज का.
तो क्या हो गया?
Austerity, not High Court is not all that glitters is not gold, not this old saying. So therefore,
High Court is so poor it cannot afford a photocopy of judgment.
I will not comment on that. I can have the copy, not the books. I can have them.
हाँ, site books बताइए, उस book को निकालते हैं.
Yes, sir. This is not 2022 volume 11 SCC, page 1.
लाइएगा भाई.
राजीव सूरी वर्सेस DDA. इसके relevant paragraphs सर मैंने extract कर दिए हैं for your lordship's convenience. Just the relevant paragraph, not because that's a very voluminous statement.
सर मैं ले सकता हूँ.
This way,
अगर मुझे मिल जाए.
एक copy दे दीजिए, इनको दे दीजिए.
I will supply a copy.
We'll share it. आप इनको दे दीजिए copy.
Thank you, sir.
This judgment I am citing for the purpose of not both judicial review of administrative action as well as not maintenance of PIL, maintainability of a PIL. These relevant paragraphs, I will not read them, but they are on the relevant and on the point notes. Your Lordship may. Because I'm on the issue of PIL note, therefore, right now I'm not, so I will refer to para 550 notes.
520, yes.
तो सर मेरे extract में देख लें उसमें last but one page.
जी.
Para 550.
520.
550 notes.
550.
जी.
जी.
Lordship have it?
Yes.
550. We may usefully advert to the exposition of Narmada Bachao Andolan versus Union of India. Citation is given notes. and they are referring to para 30 of Narmada Bachao judgment. Public interest litigation was an innovation essentially to safeguard and protect the human rights of those people who are unable to protect themselves. With the passage of time, PIL jurisdiction has been ballooning so as to encompass within its ambit subjects such as probity in public life, granting of largesse in the form of license, protecting environment and the like. But the balloon should not be inflated so much that it bursts. Public interest litigation should not be allowed to degenerate to becoming publicity interest litigation or private inquisitiveness litigation. And in not certain judgments prior to this, the Supreme Court has used certain other words also of note for a person who has invoked the jurisdiction and not whose bona fides are doubtful, which I would not like to take here.
Anything else?
That is all. Not therefore, my submission is that this PL is not maintainable. It deserves to be dismissed. Yes. And the action of the justice is perfectly proper.
Khalid साहब को कुछ कहना है क्या?
So in fact, I may just be permitted to point out certain paragraphs of the pleading from the petition itself. They are raising an issue that in fact, because this is not a recognized bar association, therefore the allotment could not have been made. This is one issue. But let me just refer to few paragraphs of the petition. In para 3.6 of the petition, what they are saying is, apart from the above, the respondent.
Just a minute. Yes.
Apart from the above, the respondent advocate bar association has illegally restricted the entry and membership and use of such allotted space to all the advocates of the respondent High Court bar association. Sir, have they quoted a single example as to who is the lawyer who was stopped from entering over there? A vague government has been made. Completely a vague government has been made. Then, my lord, may kindly come to paragraph 3.7.
Yes.
In the light of the judgment of the Honorable Supreme Court in the matter of Supreme Court Bar Association and others versus B.D. Kaushik and others, the services, premises and facilities of the High Court can be extended only and only to the recognized Bar Association and only one Bar Association. This is not what has been stated over there. It has never said. The only thing what has been said, it is a voting right which has been conferred to a member only in one bar association. He can be a member of several bar associations. There is no provision contemplated under this judgment, sir. Absolutely an incorrect statement has been made. Then, my lord, as far as the delay is concerned, there are two issues which I am raising, and how they have explained the delay is also required to be seen, my lord. Para 3.15. One more paragraph before that, before coming to that paragraph, 3.11, my lord. Therefore, it is necessary. 3.11. Therefore, it is necessary that this Honorable Court be pleased to direct that either the allotted premises, oblique the space to the respondent advocate bar association, be used equally by all the advocates, like the petitioners who are life members, so and so, so and so. Now, on the one hand, they are trying to say they want to use this space which has been allocated by the Honorable Chief Justice. On the other hand, they want the cancellation of the accommodation which has been granted to us. They are not very clear as to what they really want. The second issue which I am raising is...
That is left to be decided by a judge?
Yes. Then the delay, how the delay has been explained, that may kindly say. Para 3.15. There is a 2007. 7 and 8 the allotments were made. This petition has been filed in the year 2016. I'll come down to those judgments also which discuss in the PIL the delay. It is submitted that there is no delay in filing or challenge to the above mentioned orders when the petitioner has pointed out inherent illegalities in the allotment of the public property of the High Court to an unregistered, unaffiliated and unrecognized bar association. Further, the nature of the allotment being illegal of the subject premises came to the knowledge of the petitioner when the whole debate about one bar, one vote was initiated in this Honorable Court with the filing of the various writ petition, because the Honorable Court so-and-so, wherein the prayer for one bar, one vote principles were made in the writ petition. It is during the hearing of the above petition that the petitioner learned for the first time that the respondent advocate bar association is an unqualified, unrecognized and unregistered bar association. So what I am saying, there is a considerable amount of delay. Secondly, the person doesn't have any locus. Did he apply over there? If he's saying, if you look to the prayer clause, there are two prayers over there. It is rather, I can say that they are trying to blow hot and cold at the same time.
They want to be close to you, but they want to be close to you, but since you are not allowing them to come into your fold.
Did he make an averment that he ever applied over there and his application was rejected?
Honorary membership दे दीजिए.
Honorary membership ऐसे नहीं मिलेगी sir.
I am praying for all, not for all.
I don't want to cite that example where I can't say that where somebody's daughter applied and we were magnanimous enough to consider that application.
Whether my daughter is party in this case?
No, I never said your daughter. Why you so much worried?
Why he is making?
छोड़ दीजिए
वर्मा जी बात
लाना तो हमको भी आता है. Don't shout like this.
वर्मा जी बात
इस तरह से मत चिल्लाइए.
इतना एजिटेट होने से काम नहीं
चलता. लाना हमको भी आता है.
अरे प्लीज आप
प्लीज सर क्या करें सर?
अरे नहीं प्लीज
चुप रहना ही जानते. दिक्कत इनके साथ ये है.
आपसे रिक्वेस्ट कर रहा प्लीज, आप बहुत सीनियर है, ठीक है. ऐसा है कि इतना जल्दी रिएक्ट करने से कुछ नहीं होगा.
माय लॉर्ड, मैं कर लिया.
अभी आर्गुमेंट काउंटर आर्गुमेंट है, डिसाइड तो हमें करना है ना.
जी सर.
है, आप धैर्य रखिए. उन्होंने जो पॉइंट उठा रहे हैं, अभी मिश्रा जी ने कुछ पॉइंट्स उठाए कि आपकी पीआईएल मेंटेनेबल नहीं है, आपका लोकस नहीं है, एडमिनिस्ट्रेटिव एक्शन में क्या एक्सटेंट ऑफ इंटरफेरेंस है, उसका जवाब दीजिएगा. आप ये कह रहे हैं कि आपकी प्लीडिंग जो है वो यू आर ट्राइंग टू ब्लो हॉट एंड कोल्ड. यू ऑन द वन हैंड यू आर ट्राइंग टू सी access to the premises which has been given to them, and on the other hand you are criticizing their association itself. तो लिख लीजिए बिंदुओं को और बिंदुओं का फिर उत्तर दीजिएगा. बिल्कुल मत होइए. अब आपकी स्टेटस बदल गई है. जब आप वहां खड़े होते थे बगैर कोट और बैंड के, और आज कोट और बैंड के साथ में.
जी सर.
You will have to bring a wholesale change in your attitude.
Your lordship.
Now, Balud, may kindly have a look at the relief clause.
Please.
Number one. This Honorable Court may please to issue an appropriate writ directing the respondent Registrar General for getting the allotted space and premises to the respondent advocate bar association be vacated immediately by cancelling the relevant order of. Then the second prayer may kindly be seen, my lord. This Honorable Court be pleased to issue an appropriate writ restraining the respondent advocate bar association from charging huge membership fees from the advocate as a precondition for use and enjoyment of the space, halls and rooms allotted to it by the respondent Registrar General. Alternatively, without prejudice to the previous relief, this Honorable Court be pleased to issue an appropriate writ directing that all the advocates who are members of the respondent High Court Bar Association will be permitted to equally use and enjoy the premises and the space allotted to the respondent advocate bar association. So there's an alternative prayer, but then this is just a contrary prayer. On the one hand, if they are asking in a PIL that this accommodation be cancelled, which has been allocated to us, my lord, and on
cannot seek access to that.
No, I never say that they can't see. They apply for the membership. We'll consider their application. Now, I may point out from the bylaws which is there on the last date of hearing, I pointed out that our bylaws are saying, my lord, whoever is, the word used over in the bylaws of the constitution of our association is this, my lord. Whoever is desirous of being a member of this bar association may purchase a form from the office. No one is stopping you. Then once these application forms are purchased, you fill it up. That would be considered by a separate committee which is known as a permanent committee. The entire bylaws are there. If you do not even apply and then you say, we should be given access. Even in the Madhya Pradesh High Court Bar Association, we are members of both the Bar Association. More or less, nearly all the members in the Advocate High Court Bar Association, they are already from earlier time, they are members of the Madhya Pradesh High Court Bar Association. But when they applied over here, they were inducted as members over here. So you are required to follow a procedure. Who has stopped you? Did you ever apply? Or are you ever saying that someone XYZ applied and we did not give them the membership? It is not your case. Unnecessarily you are trying to say, because this is an unrecognized bar association. I say, my lord, as far as the recognition of the bar association, Mr. Sanjay Agarwal had probably earlier argued also, and today also you would be arguing. The recognition is a precondition in respect to the welfare schemes, my lord. Except for this, there is no other person. This is the Annexee Bar Association of the High Court. The Honorable Chief Justice has made allocation on 2 different occasions. What is wrong in that? He has excised the administrative control, the administrative authority, and then allocated. And after 7 years, 6 or 7 years, you challenge this. I would, as far as the delay is concerned, my lord, I will rely upon 2 of the judgments of our own High Court. May refer to one of the judgments, my lord, that is 2016, 3 MPLJ, page 622. This is the DB decision, my lord.
622.
Well, I will forward the copies of that. एक कॉपी
इनको दे दो, मैं इधर देख लेता हूँ, हम लोग साथ में देख लेंगे, उनको दे दीजिए.
Para 2, in the public interest litigation petition, the petitioner who claims himself to be a public-spirited individual inter alia seeks a direction to the respondent number 1 to invite bids for the railway project with a lease rent payable at the prevailing rates, and also seeks direction to the respondent number 1 not to proceed in furtherance of the agreement dated 5/6/2008, as the same has tendered commercially unviable for the respondent number 1 and the public at large. The petitioner also seeks a direction to the respondents to conduct an inquiry against the erring officer in the department of the respondent number 1 who are responsible for the mismanaging the public properties on account of their vested interest. Then, my lord, may kindly come to paragraph 12. The contract has been awarded to the respondent number 4 after inviting tenders in which he is found to be the highest bidder. The contract has been awarded in the transparent manner after following the procedure prescribed in law. It is also pertinent to mention that the aforesaid agreement was executed on 5/6/2008. This date is material, my lord. Whereas the instant writ petition has been filed after an inordinate delay of 7 years for which no explanation has been offered. The principle of delay and laches is applicable in the case of public interest litigation as well. See Bombay Dying so-and-so. Now, my lord, what I say, when the allotment was made in the year 2007 and 2008 by way of 2 different orders on 2 different occasions, the challenge has been made in the year 2016. The representations have also been submitted in the year 2016. What they are trying to explain over here that it is only during the course of the hearing. But a stand, this can be taken by a person who is illiterate or something like that, that this bar association is recognized, unrecognized, whatever it is. Whether giving such explanation by a lawyer who is filing a public interest litigation saying this, I was unaware as to whether this association is a recognized association or not. So therefore, this delay, the explanation of the delay is wholly uncalled for, that cannot be taken into consideration at all. It suffers from serious delay, serious laches, my lord. There is one judgment on the question of laches, my lord. The other judgment which I would rely upon is 2016, again 3 MPLJ page 61. But may I just forward this?
Please.
We have the copies. 2016 copies. Thank you, sir. Thank you. I'll just refer to para 1 so as to clarify the facts, my lord. The petitioner has filed the instant public interest litigation with the reliefs to stay the process of issuance of e-challan with the help of closed circuit television footage by road transport officer, and e-challans which have already been issued be cancelled and the amount recovered on the basis of the e-challan shall be returned to all concerned. He has also prayed for issuance of a writ of mandamus directing all the concerned authorities to keep CCTV recording in custody till the end of the process. Then para 12 may kindly be seen, sir. In fact, this is not a PIL. What I'm trying to say is, this has got some ulterior motives, my lord, just in order to close down this bar association. It is well settled law that there must be, I'm referring to para 12, my lord. It is well settled that there must be a real and genuine public interest involved in the litigation and not merely an adventure of knight errant born out of wishful thinking. It cannot also be invoked by a person or a body of person to further his or their personal causes or satisfy his or their personal grudge. and enmity. Courts of justice should not be allowed to be polluted by unscrupulous litigants by resorting to the extraordinary jurisdiction. A person acting bona fide and having sufficient interest in the proceeding of the public interest litigation will alone have a locus standi and can approach the court to wipe out violation of the fundamental rights and genuine infraction of statutory provision, but not for the personal gain or private profit or political move or any oblique consultation, and pray for dismissal of the writ petitions. I pause here for a moment and I say, my lord, had he been the person who applied for a membership over there and that was denied to him, he had a personal grievance, he had a personal cause of action, he could have challenged that rejection, which is not the case over here. One more judgment which I would like to refer is, my lord, that is 2000 volume 18 SCC, page 419.
2020, 18 SCC.
20 volume 18, pages 419.
Ji.
Do you have a copy, my lord? Therefore. I'm referring to para 1, my lord. A petition was filed purportedly in public interest before the Allahabad High Court by the fifth respondent. In this petition, the fifth respondent sought a direction to the state government to establish a new Tehsil building for Tehsil Hasanpur at village Karanpur Mafi. These were the facts with this background. The PIL was filed. Then I would refer to paragraph 10, my lord. Where a Tehsil building should be constructed is not a matter of the High Court to determine in the exercise of its writ jurisdiction under Article 226 of the Constitution of India. These are essentially administrative matters and a decision has to be taken by the executive. This is hence an illustration of how a public interest litigation has been utilized to subserve a personal interest. The High Court must remain vigilant to the attempts to misuse PILs to subserve extraneous and motivated purposes. Such effort must be dealt with firmly. High prerogative and writs cannot be utilized for such ends. Sir, there are three issues which have been raised by my learned friend. Number one is that this is not a recognized bar association and therefore no accommodation could have been provided by the Honorable Chief Justice. Sir, here prerogative has been exercised on the administrative side, looking to the need of the bar association, and this space has been provided on two occasions, 2007 and 2008, my lord. Now, my lord, they do not have any say in the matter. The only issue that they can raise over here is that he applied for the membership, which was dismissed, and therefore he is a cause of action. Not by way of a PIL. He cannot file a PIL. I have already argued as far as the delay and latches is concerned. It is severely hit by delay and latches. There is a serious delay in that. My lord, my learned friend has pointed out about the administrative power. This is 1998 volume 1.
1998 volume 1. 1998 volume 1.
98 volume 1 SCC, page 1.
Page 1.
In fact, I've seen this. Para 59 you are referring to, na, Sanjay ji? The conclusions have been given over here. Para 59. In fact, what has been stated over here, that the administrative control of the High Court vests in the Chief Justice alone. On the judicial side, however, he is only the first amongst the equal. Chief Justice is the master of the roster. He alone has a...
You are reading which paragraph?
Para 59, sir.
59. How it is relevant?
In fact...
How it is relevant? This kind of supply of judgments causes problem. Yes. I don't see any relevance of this judgment to the...
administrative power of the that was dealing with a separate issue. I think.
You want me to take note of this, or should we?
I don't think so, sir. This would not be applicable in this case. If we look to the facts and the background of the matter, this may not be applicable. So, in fact, I covered all those issues. And I have also said, my lord, this would be elaborately, it has been argued already by Mr. Sanjay Agarwal, my colleague, my lord, by saying...
Sanjay Agarwal argued that petition where the Bar Council has denied to give recognition.
That would cover this aspect, my lord. Recognition is required when? In order to separately answer this, my lord, because that would cover the issue as to when the recognition and what is the purpose of the recognition by the Bar Council. That is what I am saying. The purpose of recognition is not for the purpose of allocation of accommodation by the Honorable Chief Justice. It's entirely a different issue.
Yes.
That is my submission.
Yes, Abattai.
Your Lordship, both the parties have argued which are not in their reply earlier filed, Your Lordship. And
My friends, first, just one submission. Not regarding my submission to the effect that the MPSCVA notes is the primary party whose cause is sought to be espoused by the petitioner. Not MPSCVA, the party in this petition, but not on 24th notes, Lordship has recorded the proceedings. The counsel appeared not, and he said that they have not filed a reply. They are not.
That is true. That is true.
So therefore, not when the original party whose right is sought to be espoused, he is not coming forth not to say that well, my rights are being affected. Exactly. No, there was one judgment which I missed out notes that I just want to point that out. That is notes 2006, volume 6 SEC, page 180 notes.
180.
180. And the relevant paragraphs are notes para 6 onward. Para 6 onward. It's a short judgment. But here, para 6, shall I read?
Yes.
Para 6. It is necessary to take note of the meaning and expression of public interest litigation in Stroud's Judicial Dictionary. Public interest is defined thus. Public interest. A matter of public or general interest does not mean that which is interesting as gratifying curiosity or a love for information or amusement, but that in which a class of the community have a pecuniary interest or some interest by which their legal rights and liabilities are affected. In Black's law, para 6 and 7 note, they have defined a dictionary meaning they have reduced the dictionary meaning of the word public interest. Note para 8. In Janta Dal's case, this court considered the scope of public interest litigation in para 53 of the said judgment after considering what is public interest has laid down as follows. The expression litigation means a legal action including all proceedings therein initiated in a court of law with the purpose of enforcing a right or seeking a remedy. Therefore, lexically, the expression PIL means a legal action initiated in a court of law for the enforcement of a public interest or general interest in which the public or a class of the community have a pecuniary interest or sub-interest by which their legal rights or liabilities are affected. Here, there is no legal right notes. No legal right whatsoever. Para 9 notes. In para 60, 61 and 62 of the said judgment, it was pointed out as follows. 62 note. Be that as it may, it is needless to emphasize that the requirement of locus standi of a party to a litigation is mandatory because the legal capacity of the party to a litigation, whether in private or public action in relation to any specific remedy sought for, has to be primarily ascertained at the threshold. Para 10 notes. In para 98 of the judgment, it has been further pointed out as follows. While this court has laid down a chain of notable decisions with all emphasis at their command about the importance and significance of this newly developed doctrine of PIL, it has also hastened to sound a red that court should not allow its process to be abused by a mere busybody or a meddlesome interloper or a wayfarer or an officious intervener without any interest or concern except for personal gain or private profit or other oblique consideration. Thereafter, para 11. In subsequent paragraphs of the said judgment, it was observed as follows. It is thus clear that only a person acting bona fide and having sufficient interest in the proceedings of PIL will alone have a locus standi and can approach the court to wipe out the tears of the poor, needy, and suffering from violation of fundamental. Lord, this is important, Lords. PIL is meant for espousing the rights of the poor and needy and those suffering from violation of their fundamental rights, but not a person for personal gain or private profit or political motive or for any oblique consideration. Similarly, a vexatious petition under the color of PIL brought before the court for vindicating any personal grievance deserves rejection at the threshold. 12 notes. It is depressing to note that on account of such trumpery proceedings initiated before the courts, innumerable days are wasted. It's ignored, and the court not has gone on to express its anguish regarding the wastage of precious judicial time. Para 14 notes. This is the at page 185 notes. First about 5-6 lines from the top. As indicated above, the court must be careful to see that a bona fide, that a body of persons or a member of public who approaches the court is acting bona fide and not for personal gain or private motive or for political motivation or oblique consideration. The court must not allow its processes to be used for oblique consideration masked by phantoms.
You are reading para 14, na?
No, this para 13 at page 185 notes.
Para 13 at page, as indicated above.
Yes, it in fact, sir, ye shuru to usi, as indicated above. Public interest litigation is a weapon. Para 13 starts with this opening notes. Public interest litigation is a weapon which has to be used with great care and circumspection.
Yes. Judiciary has to see that behind the beautiful veil of public interest,
yes,
private
this
vested interest and or publicity seeking is not lurking.
It should be aimed at, this is 3-4 lines from the top. It should be aimed at redressal of genuine public wrong or public injury and not publicity oriented or founded on personal vendetta. And then the remaining the court has discussed. Para 15 words. The court has to be satisfied about the credentials of the applicant. Prima facie correctness of the nature of information given by him. The information being not vague and indefinite. The information should show gravity and seriousness involved. The court has to strike a balance between two conflicting interests. Nobody should be allowed to indulge in the wild and reckless allegations besmirching the character of others. Avoidance of public mischief and to avoid mischievous petitions seeking to assail for oblique motive justifiable executive actions. In such case, however, the court cannot afford to be liberal. It has to be extremely careful to see that under the guise of redressing a public grievance, it does not encroach upon the sphere reserved by the Constitution to the executive and the legislature. The court has to act ruthlessly while dealing with impostors and busybodies or meddlesome interlopers impersonating as public-spirited holy men. They masquerade as crusaders of justice. They pretend to act in the name of pro bono publico, though they have no interest of public or even of their own to protect. That is all I'm speaking. Oblige, sir.
Yes.
So first I will answer the locus standi and cause of action, Your Lordship. The petitioner is a life member of this parent body, Your Lordship. And property in question is a public property, Your Lordship. And use of public property by a selected group private body in a discriminatory manner is answered in 2015 1 SCC 720 Institute of Law versus Chandigarh Administration. Your Lordship, मैंने 2 कॉपी दी थी उस दिन आपको. ये आप अगर देखना चाहें तो अरे साहब इस केस में भी पब्लिक प्रॉपर्टी को मनमाने तरीके से एग्जीक्यूटिव ने दे दिया है और उसको वहां के रेसिडेंट ने क्वेश्चन किया है. सर ये साइटेशन है 2015 1 SCC 720. सर इसमें मैं पढ़ना चाहूंगा पैराग्राफ 20 ऑनवर्ड से जी. ऑन द बेसिस ऑफ द ऑफर से ड्राइवर, मैं पढ़ूं सर? एक मिनट.
Dealing with the question of locus standi.
Your Lordship.
जी.
On the basis of the aforesaid rival legal contentions urged on behalf of both the parties, the following points would arise for our consideration.
जी.
Whether the writ petition filed in the public interest is maintainable or not.
एक मिनट रुकिएगा प्लीज. Dealing with the question of locus standi. पैराग्राफ 20 किसका पढ़ रहे हैं आप?
उसी का 20वां पैराग्राफ सर. मैंने आपको कॉपी दी है.
हाँ, कॉपी नहीं, इससे किताब से पढ़िए ना.
मेरे पास ये है सर.
आपने कहाँ से निकाला है ये?
सर मैंने वेबसाइट से निकाला.
अरे तो ये एससीसी का नहीं होगा ना?
एससीसी है ये. आप एक स्पेयर है मेरे पास.
दिखाइए. एससीसी का लिख दिया, ये इंस्टीट्यूट ऑफ लॉ से निकाल दिया.
सर चौथे पेज में आ जाइए इसके.
If public duties are to be enforced, यही है ना?
जी सर. ये on the basis of.
एक मिनट रुक जाइएगा. ये इंटरनल पेज ये यहाँ पर है 730 पेज पर. Yes.
Madam, sir,
Huh.
on the basis of the
If public duties are to be enforced and social collective, यही तो पढ़ रहे हैं ना आप?
हाँ सर, मैं 20वां पैरा से पढ़ रहा शुरू कर रहा
तो
हूँ.
20वां पैरा यही से तो शुरू हो रहा है जो आपने फोटो दी है ये.
On the basis of aforesaid rival legal
ये तो-
contentions.
अरे आप 20 पढ़ रहे हैं, 20 तो ये शुरू हो रहा है. पब्लिक ड्यूटीज आर टू बी एनफोर्स्ड.
सर इंस्टीट्यूट ऑफ लॉ लिखा है ना सर ऊपर उसके?
हाँ, इंस्टीट्यूट ऑफ लॉ लिखा है वर्सेस नीरज शर्मा.
यस सर, यही है सर.
हाँ,
चौथा वाले में सर 20वां पैरा है सर जो पेज नंबर
करा उसमें भी पैरा 20 ही है. हमको जो सप्लाई करा.
मैं सर उसको टिक कर देता
ओल्ड
हूँ.
लेटर 20 कौन सा है? अच्छा, एक रुक जाइए, वो तो कहीं और से शुरू हो रहा है भाई. इसका आपका जो फोटोकॉपी है इसका पैरा 20 चालू हो रहा है. इफ पब्लिक ड्यूटीज आर टू बी एनफोर्स्ड, इज इट करेक्ट मिस्टर खरे?
नहीं सर, ऑन द बेसिस
That has been supplied to me. It starts from on the basis of the aforesaid rival legal contention.
एक सेकंड.
उन्होंने
अच्छा,
क्वेश्चन
ऑन द बेसिस ऑफ अफोरसेड लीगल राइवल कंटेंशंस. जी,
दोनों पार्टी ने एक दूसरे को अपोज किया है जैसे हमने किया है वैसा है.
एक से रुक जाइएगा भाई, ये तो ढूंढने तो दीजिए. एससीसी में कहीं और से है ये. ऑन द बेसिस ऑफ अफोरसेड लीगल. ये पैरा 15 है, शुरू करिए, चलिए.
On the basis of the aforesaid rival legal contentions, urged on behalf of both the parties, the following points would arise for our consideration: whether the writ petition filed in the public interest is maintainable or not, and whether the writ petitioner has locus standi to file the writ petition. Whether the separate but concurring orders passed by the division bench of the High Court, which were concurred by the nominated third judge, are legal and valid. अब इसके बाद सर अगला वाला है whether the allotment order of land made in favor of the appellant institute is in violation of Article 14 of the Constitution of India, along with applicability of the allotment of land to educational institutes, schools, rules, etc. on a leasehold basis in Chandigarh scheme 1996. उसके बाद सर पैरा 21 है. We will first consider and answer the question of maintainability of the writ petition and locus standi.
एक सेकंड, फिर आपके पैराग्राफ इधर हम लोगों को 16. yes.
पढ़ूं सर?
हाँ.
We will first consider and answer the question of maintainability of the writ petition and locus standi of the writ petitioner. The respondent number 1 herein who has filed the writ petition. The property in question, इसके बाद का है सर 22वां पैरा. The property in question belongs to the Union Territory of Chandigarh administration. Under our constitutional philosophy, it is public property and therefore belongs to the people. Hence, the Union Territory of Chandigarh administration is the trustee of the land whose duty is to see that the property is allotted in favor of eligible persons by following the procedure laid down by the Chandigarh administration, and the same should not be allowed to be squandered or sold away by it at throwaway prices, as it has been done in the instant case, as pointed out by its audit department itself, that there is a clear loss of about 139 crores. उसके बाद पैरा 23 है. It has also come to our notice that the settlement of the land in question is in favor of the appellant institute was done within a few days without following the mandatory procedure for the allotment of land. We do not doubt the intention of the appellants to set up in-law institute. However, their private interest is pitted against the public interest. The loss of the public exchequer could have been easily avoided had the land in question been settled by way of public auction, inviting applications from eligible persons, Your Lordship. Further, as stated in the writ petition, the petitioner is a resident of state of Punjab and also an income tax payer, Your Lordship. It has neither been shown or proved by appellant that he is meddlesome interpreter, Your Lordship, that he is acting under malafide intention, that he has been set up by someone, his personal scores, Your Lordship. इन्होंने भी हमारे जो जवाब दिया उसमें किसी ने कुछ नहीं कहा है, और हम यहाँ पे लाइव मेंबर हैं हाई कोर्ट एसोसिएशन के, और ये पब्लिक प्रॉपर्टी है, Your Lordship. और यहाँ पर जो देने वाले हैं, ही इज द ट्रस्टी ऑफ द पब्लिक प्रॉपर्टी. हमारा कंटेंशन ये है सर यहाँ
जी.
और इसको उन्होंने और वो किया है उसके आगे सर. Nevertheless, the broad parameters of fairness of in administration, bona fides in action, and the fundamental rules of reasonableness, management of public business, if breached, will become justicable. If a citizen is no more than a wayfarer or officious intervener without any interest or concern beyond what belong to any of the 660 million people of this country, the door of the court will not be ajar for him. But if he belongs to an organization which has special interest in the subject matter, if he has some concern deeper than that of a busybody, he cannot be told off at the gates. Although whether the issue raised by him is justiciable may still remain to be considered. I therefore take this view that the present petition would clearly have permissible under Article 226, Your Lordship. Emphasize supplied. Similarly, in the case of SP Gupta, जिन्होंने पढ़ा sir, versus Union of India, this court has categorically laid down the law in relation to locus standi as under, Your Lordship. मैं उसका पैरा 18 पढ़ता हूँ जो SP गुप्ता का जो इसमें लिखा हुआ है. Whenever there is a public wrong or public injury caused by an act or omission of the state or a public authority, which is contrary to the constitution or the law of any member of the public acting bona fide and having sufficient interest can maintain an action for redressal of such public wrong or public injury. The strict rule of standing, which insists that only a person who has suffered a specific illegal injury can maintain an action for judicial redressal, is relaxed, and a broad rule is evolved, which giving standing to any member of the public who is not mere busybody for meddlesome interpolator, but who has sufficient interest in the proceeding, Your Lordship. There can be no doubt that the risk of legal action against the state or a public authority by any citizen will induce the state or such public authority to act with greater responsibility and care, thereby improving the administration of justice. Is also necessary to point out that if no one can have standing to maintain an action but for justical redress in respect of a public wrong or public injury, Your Lordship, not only will the cause of illegality suffer, but the pupil not having any judicial remedy to address such public wrong or public injury may turn to the street, and in that process the rule of law will be seriously impaired, Your Lordship. उसके बाद अगले पैरा में लिखा है, Your Lordship.
ठीक है, चलिए और बताइए.
ये इसमें हम यही कहना चाहते हैं कि
ठीक है, आपका लोकस आपने बता दिया.
जी सर. और दूसरा इनका कहना है कि डिले मिसयूज. हमको सर ये पता चला जब जो वन वोट वन बार वाला केस फाइल हुआ, ये डेमोक्रेटिक लायर और दूसरों के द्वारा, तब इनको नोटिस भी जारी किया गया था 2016 में कि आप जवाब दो कि आप वन वोट वन बार का फॉलो करते हैं कि नहीं करते हैं. तो उन्होंने उसको कभी वो उस समय हमारा केस साथ में लग रहा था, तब हमको ये सर उसका ऑर्डर को इन्होंने इनके केस में लगाया भी है. ये WP 574 मेरे पिटिशन में भी लिखा है, तभी हमको ये पता चला. और दूसरी बात, डिले जो है इंक्रोचमेंट ऑन पब्लिक स्पेस इज अ रिकरिंग कॉज ऑफ एक्शन, योर लॉर्डशिप. एंड रिप्लाइड, मैंने रिजाइंडर में रिप्लाई दिया है साथ में, रिस्पोंडेंट वार इज क्वेश्चनिंग द डिले इन फाइलिंग पिटिशनर, हाउएवर देयर ओन कंडक्ट इज नलिफाइड, योर लॉर्डशिप. दे हैव फाइल्ड रिप्लाई रिसेंटली, योर लॉर्डशिप. इन्होंने 7 साल बाद जवाब दिया है, वो भी पैरावाइज नहीं दिया है सर.
किसने? ये
रिस्पोंडेंट जो हाई कोर्ट एडवोकेट बार है सर, इन्होंने अभी जवाब दिया है पिछले साल 6 महीने के अंदर, और वो भी शॉर्ट रिप्लाई दिया है, पैरावाइज जवाब नहीं दिया है. जो इनके अभी सबमिशंस में आया वो काफी चीजें उनके रिप्लाई में नहीं है सर. और इनका एक और कंटेंशन है कि पिटिशनर नेवर अप्लाइड फॉर मेंबरशिप एंड नेवर एग्रीड बाय एनी रिजेक्शन. दिस होल स्टेटमेंट इज एब्सोल्युटली मिसकंसीव्ड, योर लॉर्डशिप, बिकॉज पिटिशनर इज नॉट इंटरेस्टेड इन जॉइनिंग एनी क्लब, योर लॉर्डशिप, but he is interested in fair and free use of the public property which is allotted to the selected persons, your lordship. And by alternate remedy which was considered by this honorable court was for not for myself, your lordship, for all the life members of the High Court Bar Association. I don't want to be a paid member of any club, your lordship. अब सर आपने हाई कोर्ट से पूछा था कि आपने किस अधिकार से इनको दिया है, तो उन्होंने पहले तो अपने जवाब में कहा कि डिस्क्रिशन यूज किया है, विजडम यूज किया है, कोई जवाब नहीं दिया. और उसके बाद अभी ये कह रहे हैं कि इनको इनहेरेंट पावर है इसलिए दिया है, और उनका ये भी कहना है कि कोई रूल्स फ्रेम नहीं है, कोई पॉलिसी नहीं है इसके बारे में. हमारे इसके बारे में सर मैं कुछ जजमेंट देना चाहूंगा कि इनहेरेंट पावर ऑनरेबल चीफ जस्टिस को कैसे एक्सरसाइज करने चाहिए, वो ऑनरेबल सुप्रीम कोर्ट ने बताए हैं, तो मैं पढ़ना चाहूंगा सर. मैं इनको भी दे रहा हूं सर.
जी. हाई कोर्ट को भी दे दीजिए एक कॉपी, फिर हाई कोर्ट आपको नहीं देता है कॉपी.
सर वो अगल बगल में बैठे हैं.
अरे अगल बगल में नहीं होता, मिश्रा जी अलग पार्टी है
सर.
नाउ मिश्रा जी, यू कैन नॉट डिनाई हिम कॉपी एक्सेस टू द. अब आपको स्पेशली दिलवा दिया है.
मैं 5-6 करा के लाया.
नहीं ठीक है,
मैं पढ़ूं सर.
पढ़िएगा प्लीज।
whether the
ये तो नोट बना लाए आप
सर, मैं उसमें जजमेंट है ना सर सारे।
जजमेंट बताइए बस,
बता रहा हूँ
उतना पढ़िए
जी सर।
जजमेंट बताइए, जजमेंट का रिलेवेंट पैराग्राफ पढ़िए।
This question whether Chief Justice can exercise disregarding the constitutional provisions came up for consideration before the apex court in the case of H.C. Puttaswamy versus Honorable Chief Justice of Karnataka 1991 AIR 295 है your lordship, और SCC का है 1991
इसके बाद क्या हुआ?
The apex
रिलेवेंट पढ़िए
जी sir. The apex court has observed thus at para 11 your lordship. The judiciary is the custodian of the constitutional principles which are essential to the maintenance of rule of law your lordship. ये जजमेंट उस समय का है, उस बात के ऊपर है कि कई जो क्लर्क्स की जो भर्ती कर ली गई वो जो स्टेट के रूल्स के खिलाफ कर ली गई और उसमें उन्होंने इनहेरेंट पावर यूज कर लिया, उसको उन्होंने क्वेश्चन किया है और उस पिटीशन को अलाउ किया है सर। The judiciary is the custodian of the constitutional principles which are essentials to the maintenance of rule of law. It is the vehicle for the protection of a set of values which are integral part of our social and political philosophy. Judges are the most visible actors in the administration of justice. Their case decisions
अरे
are
जो ये हाईलाइटेड है उतना पढ़ लीजिए, उतना ही आप बताना चाहते हैं।
Yes sir.
हाँ, अब अगला जजमेंट।
But the Chief Justice or any other administrative judge is not an absolute ruler. Not he is freewheeler. He must operate in the clean world of law, not in the neighborhood of sordid atmosphere, your lordship. He has a duty to ensure that in carrying out the administrative function, he is acquitted by some principles and values as those of the court he is serving. He cannot depart from the indeed must remain committed to the constitutional ethos and traditions of his calling, your lordship. We need hardly say that those who are expected to oversee the conduct of others must necessarily maintain a higher standard of ethical and intellectual rectitude, your lordship. The public expectation do not seem to be less exacting, your lordship. इस केस में भी क्या हुआ है कि कुछ लोगों ने ये कहकर एप्लीकेशन दिया कि हम थोड़े से मुट्ठी भर के सीनियर एडवोकेट से हमको बैठने के लिए जगह दी जाए। उन्होंने उस वक्त ये नहीं बताया था कि हम अलग से कोई बॉडी बनाएंगे, और जो इन्होंने बोला कि हम वहाँ किसी का आना जाना नहीं रोकते हैं। सर इनके वहाँ पे फोटो में खींची है परसों मैं वो दिखाना चाहता हूँ आपको भी। उसमें लिखा है कि ओनली मेंबर्स, मतलब इनके जो क्लब के मेंबर्स हैं वही आ सकेंगे।
I have an objection to call us club.
That is in my pleading.
Manoj ji, बात
That is in my pleading.
Very rightly said that now my brother should confirm he's become a lawyer now. He's not, we are not having a performance ballot on a चौराहा.
नहीं बिल्कुल, मैंने आपके पहले ही बोल दिया है, ठीक है। उसके उनके क्लब बोलने से आप क्लब नहीं हो जाएंगे। You will still continue to be a High Court Advocates Bar Association. So please.
Sir, it is not. Sir. It is in my pleading. It is mentioned here.
वर्मा जी वेट करिए, प्लीज वेट करिए। अग्रवाल साहब प्लीज, ऐसा है नहीं देखिए, बात सुनिए, ऐसा है क्या आर्ग्यू करना चाहिए, कैसे आर्ग्यू करना चाहिए, दैट इज समथिंग डिफरेंट। बट आई एग्री कि किसी के लिए बारे में भी कोई पर्सनल रिमार्क नहीं होगा, ठीक है। आप क्लब नहीं, इट इज, आप उसको हाई कोर्ट एडवोकेट्स बार एसोसिएशन है, वही करिए। आप बाकी जो सबमिशन कहना चाहते हैं हम सुन रहे हैं
जी सर।
इस तरीके से प्लीज वेट, that is not the issue right now. We are not adjudicating whether you are the best or second best. Issue right now is something different. I'll restrain him from using a. Please.
It's a club or not. This is not an issue, Lord.
Please wait. Have patience. Please sit down.
सर अब मैं हाई कोर्ट एडवोकेट बार एसोसिएशन कहता हूँ सर।
हाँ।
तो ये इनके एसोसिएशन के बाहर लिखा हुआ है, मैं इनको भी एक फोटो दिखा देता हूँ।
दे दीजिए।
सर ऐसे क्या फोटो लेंगे?
सर मैं जस्ट दिखा ही रहा हूँ बस।
ये कुछ भी ऐसे बढ़ा देंगे यार?
कुछ भी नहीं बढ़ा रहा हूँ, मेरे प्लीडिंग पे लिखा है।
ठीक है, रिकॉर्ड पर नहीं आएगा तो नहीं लेंगे।
सर वो नो एंट्री का बोर्ड लगा है वहाँ पे। सर मैं बोल रहा हूँ
ऐसा अभी हमें
इनको खुश करने के लिए और क्या है?
नहीं ये कोई बात नहीं है।
ले लीजिए, अगर जब वो फाइल करेंगे रिकॉर्ड पर तब लेंगे, उसको कंसीडर करेंगे, नहीं तो नहीं करेंगे।
सर मैंने अपने प्लीडिंग
अरे दे दीजिए, एक कॉपी दे दीजिए।
दिखा देता हूँ सर।
अरे कॉपी दे दीजिए आप आपको।
सर ये आपको दिखाना चाहता हूँ। ये हमारी प्लीडिंग में हमने लिखा है कि इनके बाहर एक बोर्ड लगा है कि ओनली मेंबर्स। हम यही कहना चाहते हैं इस फोटो के द्वारा, और कुछ नहीं कहना चाहते हैं। तो इनका कहना है कि हमारे यहाँ सब आ सकते हैं, पर दे आर सब्जेक्ट टू देयर कंडीशंस। और जो इन्होंने जगह मांगी थी सर तब उस वक्त नहीं बताया था कि
अभी तो ये इशू ही नहीं है, अभी तो इशू यह है आपका लोकस
जी जी
और चीफ जस्टिस साहब का प्रेरोगेटिव,
अभी सर वो आगे पढ़ रहा हूं सर।
हाँ उसका उतना बताइए।
हाँ सर, अब इसकी इसी में सर लास्ट में लिखा है सर, इन द केस ऑफ महेश चंद्र वर्सेस रीजनल मैनेजर यूपी फाइनेंशियल कॉर्पोरेशन 1993 2 SCC 279, the apex court has held that every wide power, the exercise of which has far-reaching repercussion, has inherent limitation on it. It should be exercised to effectuate the purpose of the act, your lordship. In legislation enacted for general benefit and common good, the responsibility is far graver, your lordship. It demands purposeful approach. The exercise of discretion should be objective. The test of reasonableness is stricter, your lordship. The public functionaries should be duty conscious and rather than power charged, your lordship. Its actions and decisions which touch the common man have to be tested on the touchstone of fairness and justice. That which is not, अगले पेज में सर, fair and just is unreasonable, and what is unreasonable is arbitrary. And arbitrary action is ultra vires, your lordship. It does not become bona fide and good faith merely because no personal gain or benefit to the exercising discretion should be established. In the case of High Court of Judicature of Rajasthan versus Ramesh Chandra Paliwal 1998 3 SCC 72, your lordship. The apex court, while dealing with Article 229 of the Constitution, has observed that the judges have to live and behave like hermits, your lordship.
ठीक है, वो तो हो गया, चलिए.
And their mission is to supply light and not heat. And the relevant paragraph is 38 to 40, which is under, your lordship.
ठीक है. और क्या बताओ? ठीक है, don't read it.
सर इसमें हमारा कहना है कि इनहेरेंट पावर एब्सोल्यूट नहीं है.
हाँ ठीक
है. वो रूल्स और रेगुलेशन के द्वारा गवर्न होना चाहिए.
We have taken note of this fact. चलिए.
इसके बाद सर ये एक और जजमेंट है सर, रेनू एंड अदर्स वर्सेस डिस्ट्रिक्ट एंड सेशन जज 30 हजारी एंड अनदर 2014 SCC 50 सर. ऑनरेबल सुप्रीम कोर्ट ने ये ऑब्जर्व किया है पैरा 5 से सर. रूल ऑफ लॉ इज द बेसिक फीचर ऑफ द कॉन्स्टिट्यूशन, योर लॉर्डशिप. देयर इज अ टाइम व्हेन रेक्स एंड वाज लैक्स. वी नाउ सी टू से लैक्स इज रेक्स, योर लॉर्डशिप. It is axiomatic that no authority is above law and no man is above law. तो इनका ये कहना है कि जो चीफ जस्टिस साहब के जो उन्होंने जो अलॉट किया उसको कोई क्वेश्चन नहीं कर सकता. वो गलत है सर. इन्होंने जो 2 जजमेंट बताए, एक तो मास्टर ऑफ रोस्टर के बारे में था और दिल्ली पुलिस एक्ट के बारे में, दोनों इससे रिलेवेंस नहीं रखते हैं.
ठीक है. और
जो आपने पूछा था वो भी नहीं बताया.
ठीक.
और it is axiomatic that no authority is above law and no man is above law. Article 13(2) of the Constitution provides that no law can be enacted which runs contrary to the fundamental rights, your lordship, guaranteed under Part 3 of the Constitution. The object of such a provision is to ensure that instruments emanating from any source of law, permanent or temporary, legislative or judicial or any other source, pay homage to the constitutional provision relating to fundamental rights, your lordship. Thus, the main objective of Article 13 is to secure the paramountcy of the Constitution, especially with regard to fundamental rights, your lordship. इसके बाद पैरा 6 में इन्होंने लिखा है सर, the aforesaid provision is consonant with the legal principle of rule of law, and they remind us of the famous words of the English jurist Henry and Bracton, your lordship. The king is under no man but under the God and the law, your lordship. No one is above law. The dictum be you ever so high, the law is above you, your lordship. तो इनका कहना है कि चीफ जस्टिस साहब ने जो कर दिया वो कर दिया, उसको कोई क्वेश्चन नहीं करेगा. उसका ये जवाब है सर. Is applicable to all, irrespective of his status, religion, caste, creed, sex, or culture, your lordship.
ठीक है. अरे ठीक है, let him complete. उन्होंने आपके टाइम में इंटरप्ट नहीं किया. अरे he is not making any. अरे नहीं, देखिए बात सुनिए, हमें तो सुनना है. अब हम पेशेंटली सुन रहे हैं. अरे मिश्रा साहब, हम पेशेंटली सुन रहे हैं, जो रिलेवेंट होगा उसको लेंगे. भाई देखिए, हमें तो
So what my learned friend is trying to say, कि the manner and the tone and tenor in which the argument is being raised against the allotment by the Chief Justice is slightly incorrect. That is going live.
Okay.
That is the only thing that he's trying to.
What we'll do? ठीक है, I have understood. हम इसकी लाइव स्ट्रीमिंग बंद कर दीजिए. ठीक है. I have understood. Okay.
That is the main thing.
अभी कर देते हैं इसको, लाइव स्ट्रीमिंग बंद कर देते हैं. उसका म्यूट भी करना पड़ेगा सर.
you.